Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order this morning. Madam Secretary, could you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner. Assemblywoman Marzola.
Here.
Assemblyman Miller. Assemblywoman Nguyen.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. Quorum. 2 members are absent right now, but I expect them to be here shortly. So I will try to remember to mark them present when they arrive. For the moment, please mark them absent excused. But as I said, I do expect them to be here. Good morning, everyone, and welcome to Assembly Committee on Judiciary. I believe this is day 10 of the 81st session of the legislature, and I want to welcome the members, our presenters who are here with us on Zoom, and members of the public who may be watching either on the legislature's website or on our YouTube channel. Before we open up the meeting this morning, I'll go over just a few really brief housekeeping matters. Members and presenters on the Zoom, if you can remember to mute your microphone when you're not speaking, that will help with any feedback. We do expect courtesy and respect in this committee. We don't always agree on policy. In fact, there may be disagreements on today's bill, but we need to make sure we're being respectful to each other and to the legislative process. And that also includes our very hardworking staff as well. And then finally, members are often we're looking at multiple devices. I feel like we're in a gaming tournament with the amount of monitors and screens we're trying to navigate in this virtual world. So please don't see it as a sign of disrespect or inattention. If members are looking away, they're probably looking at iPads or other screens to look at the exhibits that we're going through today. So with that being said, we're going to go to our agenda. And I just want to give everyone a lay of the land in terms of the order in which we're going to take these agenda items. So we have 2 presentations today, as well as our first bill hearing. We're going to do the presentations first, and essentially, I guess we're going to go in the order that they're listed on the agenda. So the presenters who are on and Chief Lawson, you'll be at the end of the meeting. So I just ask for your indulgence and patience as we get through the first 2 agenda items. So at this time, I want to open up our first presentation, which is an overview of the Nevada Judiciary. Members, as usual, there is an exhibit on Nellis. That is the presentation that Justice Hardesty will be going through. For members of the public, you can also pull that up on Nellis, follow along. But I want to welcome to the committee for the first time this session, and certainly not the last time, Chief Justice Jim Hardesty from the Nevada Supreme Court. Justice Hardesty, as always, it's great to have you in the committee. Have enjoyed working with you over the past couple of sessions. And when you're ready, please go ahead with your presentations, and then I'm sure we'll have some questions for you at the end.
Thank you, Chair. I'm going to endeavor to create this screen share. I hope that worked.
Justice Hardesty, it is not, we can still see your notes basically. So if you could go into your display settings. I believe it's up at the top.
Yes, ma'am.
And swap view and slideshow, I believe. There we go. Perfect. You are good to go, Justice Hardesty.
Okay, thank you so much. Let me begin by expressing my appreciation to the chair and to the members of the committee for allowing me to present an overview as requested by the chair of the Nevada Judiciary and offer some additional information with regard to criminal procedure. I'd like to also begin by expressing my compliments and congratulations to each one of you who've been selected to sit on the Judiciary Committee for the Assembly. In my view, it's one of the more challenging committees that exist in the legislature. You will be confronted with numerous conflicting, significant policy choices. And I just want to let you know in advance that the court, the judges of the state, the administrative office of the courts stand ready to provide you with data and resources and information as you might need to help evaluate some of the issues that come in front of you. I want to mention to you that in that regard, the court has hired a new director of the administrative office of the courts, and the state director is Catherine Stocks. She will be joining us this coming Tuesday. She is a court administrator that comes from the largest judicial district in Kansas. Very, very capable, qualified individual. In addition, many of you have met and have dealt with John McCormick, who is the Deputy Director of the Administrative Office of the Courts, a very capable and experienced administrator who has had considerable experience in contact with the legislature. In addition, the court has asked again for the services of Ben Graham to assist us in communicating with legislators who have questions and get them data and information. And the Ferraro Group has also been offered to be available to assist legislators in their needs for data and information. Throughout my presentation, I'm going to mention some reports, so you may wish to make some notes on your slides if you have them, because there's some very important, valuable information that will assist you, I think, in your work as you progress through the legislative session. Let's begin then with an overview of Nevada's judiciary. And begin by noting first that Nevada is comprised of 11 judicial districts. As you can see on the map, we have 11 of those districts. The district number 1 is in Carson and Story. Judge Wilson and Judge Russell sit as the district court judges in that district. That's a very important district because most of the lawsuits that occur in the state that involve significant constitutional challenges or administrative department activities will arise or be originated in that district under the Constitution. District 2 is Washoe County. District 8, of course, is the largest judicial district, and I'll talk a little bit about the statistics here in a moment. And as you can see, the various district numbers around the state. The 11th district in pink may seem unusual. We asked the legislature to create that district as a means of efficiency and caseload spread. It is served by one judge, Jim Shirley. And as you can see from the area, he travels the most of any district judge in the state. He's in his car probably more than he's in court, but he has committed to that effort, and it has proved to be very successful in providing judicial services to the people who live and work in Pershing, Lander, and Mineral County. It's really added to the capabilities of the judicial system to provide access to justice in those communities. This map describes the Nevada court structure, if you will, and it also references the number of judicial officers in each of the various district courts. For your notes or for your information, you, like us, operate under the Constitution. Article 3, Section 1 of the Nevada Constitution describes powers of the government of the state of Nevada to be divided equally between 3 departments: the legislative, the executive, and the judicial. As you know, the judicial branch is a co-equal branch with your branch and with the executive branch of the Nevada government. The judicial power, it resides in Article 6, Section 1 of the Nevada Constitution, and provides that the judicial power of this state shall be vested in a court system comprising of the Supreme Court, a Court of Appeals, district courts, and justices of the peace. So as you can see, and by the way, there's a separate provision allowing for the creation of municipal courts. There are 7 justices who sit on the Supreme Court. I have the privilege of serving for my third time, I should say, as Chief Justice of the court. Article 6, Section 19 of the Constitution provides that the Chief Justice is the Chief Administrative Officer of the court system in the state. And there are various statutes and other provisions that empower the Chief Justice to undertake various matters relating to the administration of Nevada's court system. The Supreme Court handles court cases that are direct appeals of all criminal cases of felony and gross misdemeanor magnitude, as well as all civil cases over a certain dollar amount, which we'll get to in a minute. The court also has original jurisdiction to entertain various writ proceedings, original writ proceedings, or appeals from a writ proceeding in which someone is being compelled to do something or prohibited from doing something, or which jurisdiction questions arise, or habeas corpus disputes in criminal cases where there is a post-conviction review of a particular conviction. District courts are generally characterized as the general jurisdiction court of our state. They hear all civil, criminal, family, and juvenile cases subject to some dollar or crime type jurisdiction. This slide mistakenly reports 82 district judges. There are 90 district court judges now since the last legislature, residing in the 11 district courts of the state. The Court of Appeals was created by the legislature and at least initially proposed by the legislature in sessions in 2011 and 2013, and the voters in November of 2014 approved after 5 tries the creation of a Court of Appeals. The Court of Appeals came online in January of 2015. It is much different, perhaps, than what most people think about in terms of an intermediate Court of Appeals. We selected a model that is called a push-down model, which allows for improved case management and efficiency of the appellate court system, and provided what is called an error correction court, a court that hears cases that are sent down to them after they've been filed with the Supreme Court and have been fully briefed. And that court then resolves cases that are of an error correction type. Infrequently, they may publish an opinion, and they certainly have the authority to do so, which is an order or an opinion, I should say, that has precedent, legal precedent, as it affects other cases in the system. But the vast majority of the cases that the Court of Appeals deals with are error correction cases that are important cases, but principally important just to the litigants in that case and do not establish any legal precedent for other case types. There are 3 judges on the Court of Appeals. The chief judge of the Court of Appeals currently, just reappointed him, is Michael Gibbons, who served as a district court judge during his career in Douglas County in the 9th Judicial District. Also serving with him is Judge Bonnie Bula, who is a former discovery master in Clark County, and Judge Jerome Tao, who was a former district court judge in that county. I want to mention my colleagues on the Supreme Court. I overlooked that, didn't mean to. You may see one or more of them appear in front of you. Associate Chief Justice this year is Ron Paragari. Justice Lydia Stiglich is on the executive committee with Justice Paragari and myself. And also on the court is Justice Alyssa Kadish, Justice Abby Silver, Justice Christina Pickering, and most recently elected Justice Doug Herndon, who is a district court judge from Las Vegas. Completing the structure of the court system are the justice courts. They are courts of limited jurisdiction. Their jurisdiction is established primarily by statute, and it was enacted by the legislature. They handle criminal, civil, and traffic matters, principally criminal matters that are of a misdemeanor nature, civil matters that are reduced dollar sums, such as small claims court matters. They handle summary evictions and various other matters prescribed in the statute. There are 66 justices of peace who serve in 41 justice courts. And in some of our cities, municipal courts have been created. They too have limited jurisdiction, handle certain misdemeanor criminal matters, limited civil matters, and primarily traffic matters. There are 30 municipal court judges who preside in 17 municipal courts around the state. As I mentioned earlier, the Nevada Judiciary is one of 3 branches. The responsibility of the judiciary I've already covered, and what the Nevada court system consists of in terms of its structure. The state's ultimate judicial authority under the Constitution is the Supreme Court. The Supreme Court, as I mentioned earlier, is responsible for the administration of the Nevada judicial system, decide or assign to the Court of Appeals civil and criminal cases that have been appealed, engage in extraordinary writs. Also, perhaps of interest to you, the judicial branch is exclusively responsible for the licensure, the establishment of rules of professional conduct for lawyers and for judges, and it is the final appellate review for cases involving judicial discipline of judges found to have been guilty of misconduct by the Judicial Discipline Commission. I mentioned the Court of Appeals duties earlier, and the number of justices that are on the court. I've already covered the Court of Appeals. This slide just restates some of the information I have previously mentioned. This slide now addresses the district courts, expanding a little bit on what I mentioned about their general jurisdiction. The district courts in the Constitution will hear all felony and gross misdemeanor criminal cases, as well as family, juvenile, and civil cases with a value over $15,000. All appeals of district court decisions go to the Supreme Court, subject to being pushed down to the Court of Appeals. There are 11 judicial districts, as I noted earlier, with 90 district court judges. We've already discussed the Justice Court's general jurisdiction, which is misdemeanor criminal matters and traffic cases. I do want to touch on their role in preliminary hearings for gross misdemeanors and felonies. We'll speak about that a little bit later in the slides, but they principally focus on determining whether a crime has been committed and whether the individual who committed the crime there's probable cause to believe that that defendant is the one who committed the crime. That process takes place in hearings called preliminary hearings in front of the justice courts. And that defendant has the opportunity to challenge the information and the evidence that's presented to the justice of the peace to determine whether they should be bound over to the district courts for further proceedings in gross misdemeanor and felony cases. Justice courts also hear traffic cases and civil matters. There's small claims. In 2000, I believe in 15, the dollar amount for small claims was increased to $10,000. Civil cases jurisdiction was increased to $15,000. There will be a bill this year that is in the legislature that asks the legislature to reconsider the dollar amount for small claims, reducing it from $10,000 to $7,500. And the Justice Court judges will be appearing in front of you to discuss that bill and explain why that might be appropriate for your consideration. The Justice Courts also issue protection orders. And as I mentioned earlier here, landlord-tenant cases involving eviction proceedings. Justice courts are referred to as the limited jurisdiction. And as I mentioned, there are 40 justice courts and yes, 67 justices of the peace. The district courts in our state are principally responsible for appellate jurisdiction over justice court decisions. So if someone is aggrieved and wants to appeal a justice court decision, they will appeal to the district courts for that purpose. The next slide, oops, did I do that right? Let's see here. This slide repeats some of what I previously mentioned, just inserted it here for your reference as to which kinds of criminal court cases go into which courts. We'll talk a little bit in a moment about how they get there. In Nevada, there are certain offense classifications. Misdemeanors, described in NRS 193-150. Those are crime types in which the maximum penalty is up to 6 months in jail and a $1,000 fine, plus administrative assessments that are established from time to time by the legislature. There's no right to counsel unless jail time is intended upon convictions, and those convictions are appealable to the district court, as I mentioned earlier. Gross misdemeanors provided for in 193-140 are a maximum penalty of up to 364 days in jail and a $2,000 fine. They're eligible for formal probation. There's right to counsel at all stages of those proceedings. There are preliminary hearings in justice court, as I mentioned earlier, to determine probable cause as to whether a crime has been committed and whether the defendant committed it. And then convictions are appealable to the Supreme Court and the Court of Appeals. And then there's felonies. The most serious of crime types are broken down into 5 categories. Categories A through E, depending upon severity. This is a system that was established in 1995 when the legislature created truth in sentencing. But it has been revamped and a number of crimes have been realigned as a result of the chair's work and the vice chair's work and the work of the judiciary and the legislature in the last session of the legislature when AB 236 was passed, a major criminal justice reform measure that realigned several of the crimes between and among categories A through E. That becomes important because it influences the penalties that are assessed for the crimes that are fitting within those various categories. Penalties in this area of crimes can range anywhere from 1 year to state prison, in-state prison to death. The right to counsel, of course, exists at all stages. Anyone accused of a felony is entitled to a preliminary hearing in justice court for probable cause determination. And those convictions entered in the district court, whether by plea or by verdict through a jury trial or bench trial, are appealable to the Supreme Court and the court or pushed down to the Court of Appeals. Another way in which a defendant may end up in front of the justice system is through a warrantless arrest stemming from an arrest occurring in the officer's presence. The arresting officer must file a probable cause declaration with the court. The court must review the declaration within 48 hours to determine whether probable cause exists for the arrest. The court can conduct this review in camera if the court finds that probable cause detention exists. Detention may continue, but there are some changes that have occurred with respect to the continued detention and the release of defendants, which I'll talk about in a moment, sometimes referred to as the bail process. In custody defendants must be brought before a magistrate within 22 hours of arrest for warrant or warrantless arrests, and for their initial appearance called an arraignment. And as we'll talk about in a moment, release conditions and bail are set at the initial appearance, although in some courts, particularly in Clark County, new processes have been developed for handling of misdemeanor offenses through a first appearance court. Right to counsel attaches at the initial appearance, and the arrest may be made by warrant issued upon a complaint or a summons as well. A grand jury, we often hear about grand juries. The grand jury is impaneled by the district courts throughout the state. It's not exactly the same way that a regular grand jury is selected, even though this slide suggests that, but rather a grand jury is drawn from a pool of individuals that are reached out by the commissioners, jury commissioners in the counties in which grand juries are used. It is interesting that principally the grand juries are used in Clark and Washoe County, and frankly, very little or almost not at all in most of the rural counties in the state. The district courts select the grand jurors to serve, and they are responsible for hearing evidence presented by the prosecutor to determine if a person should be indicted or charged with an offense. The prosecutor is obligated to present any exculpatory evidence during that proceeding. If 12 or more grand jurors find probable cause, then what is called a true bill will issue by the grand jury. It is presented to the presiding district court judge supervising the grand jury process at the time, and the defendant will then be indicted and subject to arrest. The grand jury process can be used in lieu of a preliminary hearing or in addition to a preliminary hearing if the defendant was not previously bound over, subject to some limited exceptions. Arraignments is the first time in a criminal prosecution when a defendant is brought before the court to hear the charges against him or her and to enter a plea. Gross misdemeanor and felony defendants will have a formal arraignment in front of the district court. upon bind over or upon following arrests from a grand jury indictment. At the time of arraignment, the defendant then is expected to respond to the plea and make a plea of guilty, not guilty, other alternative pleas, not an Allen, but a no contest plea, if you will, excuse me. And oftentimes that is a point in the proceeding where plea negotiations are reported to the court. The right to counsel applies to all defendants who face loss of liberty. A defendant can voluntarily waive his or her right to counsel. However, the district courts are required under a United States Supreme Court case called Ferretta to make sure the defendant is knowingly and voluntarily and intelligently waiving his or her right to counsel. As I mentioned, the preliminary hearing process takes place in front of the justice courts when an individual is charged with a gross misdemeanor or felony. We've talked about the probable cause process in the preliminary hearing, and the preliminary hearings in just one addition, the preliminary hearings in death penalty cases must be recorded by a court reporter. All other preliminary hearings can be recorded using electronic means. A misdemeanor trial occurs in justice or municipal courts and are in front of a bench, in front of the judge, if you will, save and except certain domestic violence cases. In a bench trial, there's no jury, and the judge is the finder of fact who makes the determination as to the verdict and then later imposes sentence. There's no right to a jury trial when the penalties are de minimis in misdemeanor cases, that is less than 6 months, except in domestic violence cases pursuant to a September 2019 opinion of the Nevada Supreme Court in Anderson versus District Court. That case essentially held that jury trials are available to defendants who request them in misdemeanor domestic violence cases because of the consequences established by the legislature concerning that individual's access to an available or requirement to report and register gun use. The court in Anderson concluded that that makes this a serious offense, and as a result is subject to a jury trial upon request of the defendant. Justice courts generally use 6-person juries. This slide is a little bit older. It references 2017. It should not, but the statistics aren't too far off. Each legislator should have received, and if you didn't, please let my office know and we'll make sure you get a copy of the Supreme Court's 2020 annual report of the Nevada Judiciary. That booklet, several pages long, contains a breakdown of all of the case numbers, filings, dispositions in the various justice and district courts around the state. It is a very valuable resource, I think, for you to add context to some of the information that we've been providing to you. And one thing that catches people's attention is that non-traffic misdemeanors, only about 1% of those end up going before a justice of the peace or a municipal court judge for a bench trial. And frankly, less than 2% less than 0.2% of traffic misdemeanors are disposed of by a bench trial as well. So the vast majority of traffic misdemeanor offenses are resolved through the payment of a fine or fee, an administrative fee, and the defendant's agreement to resolve the case in that manner. And the vast majority of non-traffic misdemeanors are resolved through plea rather than through a trial in front of the court. Gross misdemeanor and felony trials, we've talked about those and where they occur in the district courts. A defendant, as we've previously mentioned, can waive their right to a jury trial. Again, this slide references fiscal year 2017, but I can tell you the same Nevada reports that I just referenced for 2020. And that's why I wanted to reference that book, so you had not only the current statistics, but also the numbers that are contained in that report. Illustrate that approximately 1.3% of all felony cases are disposed of through a jury trial. It's a very small percentage of criminal cases that actually end up going to a jury trial. Less than 0.3% of gross misdemeanors are disposed of through a jury trial. What about that? Why is that the case? Because it is a fact that about 98% of the criminal cases in the state, and that's not uncommon, by the way, for the rest of the country, are resolved by plea negotiations through prosecutor and defense counsel or the defendant. The percentages are small. I don't want to understate, though, the work involved. Many of the jury trials can involve trials that take weeks and are very complex. So even though the percentage looks small, as you'll see from the case numbers that are in the schedules in the court's annual report, the requirement to conduct those trials and the time that it takes to do so is still very substantial. Frankly, the system as a whole is fortunate that most of these cases are resolved by plea negotiations. In Nevada, a defendant and the prosecution each get preemptory challenges when they are conducting voir dire of jury trials. A significant topic of interest that has been the subject of a number of authored opinions by the Nevada Supreme Court involves the use of preemptory challenges by prosecutors against or having to do with those of racial minority. The Supreme Court of Nevada has established very clear guidelines that district courts are to follow when a so-called challenge or a preemptory challenge is made in connection with a U.S. Supreme Court case called Batson versus Kentucky. And it precludes discriminatory conduct in the exercise of preemptory challenges that would strike a minority juror from the case. That also extends to other types of discrimination, including gender. And so that area has been a hot topic for the past several years. And I think a lot of the cases that have been decided by the Nevada Supreme Court recently have established quite a bit of information that deals with how that should be handled in trials that could take place in the Nevada district courts. Jurors are generally 12 folks selected from the community. That too is an area of considerable interest. Where do those jurors come from in the community and how are they identified? In 2017, the legislature expanded the sources to be used by jury commissioners when identifying individuals that should be the subject of the veneer that make up prospective jurors for jury selection. If a defendant pleads or is found guilty by trial, there is a sentencing proceeding, separate and apart from the process that resulted in the individual's conviction. Prior to that hearing, there is a pre-sentence investigation report provided by the Division of Parole and Probation. Since AB 236 was enacted last year, pre-sentence investigation reports no longer include a sentencing recommendation. That determination is now entirely within the discretion of the district court. And after hearing testimony and argument from the prosecution and the defense, and within the sentencing guidelines that are established in the statutes that penalize this particular crime. Judgments of conviction arise as a result, as I mentioned earlier, of a negotiated plea or a verdict following a bench or jury trial. The sentence is set, the term of imprisonment and conditions of sentence are established by the district courts, including the imposition of any fines, fees, or restitution. And then the defendant is entitled to credit for time served if they were incarcerated or detained before the conviction was entered. I understand you will hear some bills dealing with the death penalty, perhaps this year, so that you have a limited amount of background behind this matter. The DA must file a notice of intent to seek the death penalty within 30 days of filing of an indictment or information for following bind over. You may hear a lot of conversation about Supreme Court Rule 250. Supreme Court Rule 250 is a rule adopted by the Supreme Court that sets out particularized educational and experience requirements for defense lawyers and even judges to be able to participate and hear death penalty cases. The death penalty area is one of the more complex and ever-changing areas of the law and is influenced frequently by U.S. Supreme Court decisions on multiple aspects of criminal cases that involve the death penalty. The death penalty can only be imposed following a separate penalty hearing in front of the jury that determined conviction and requires a weighing of first a finding of and then a weighing of aggravating and mitigating circumstances involving the case and the defendant's behavior and the defendant's mitigation factors. And there is an automatic appeal in all death penalty cases directly to the Supreme Court of Nevada. And those automatic appeals compel, and jurisprudence requires that the Nevada Supreme Court make an independent assessment as to whether the death penalty should be imposed. Some time ago, and I don't recall exactly how many years ago, but I think it was just about 4, maybe only 2, but a study was requested concerning the average cost of the imposition of the death penalty. I believe that report indicated $532,000 more than a murder case. I mentioned that just because of that report, and I imagine that when you get around to that testimony, you'll get some more information about that report and how it was compiled. In Nevada, in addition to the imposition of a sentence provided by statute, certain penalties, or certain crimes, I should say, are subject to enhancements. That is, in addition to the sentence associated with the crime type, depending upon how the crime was committed, or depending upon who the victim was, might result in further enhancement penalties. So, for example, a felony committed with the assistance of a child might result in an additional 1 to 20 years beyond the crime itself. The use of a deadly weapon may result in additional 1 to 20 years, depending upon the determination by the district judge for the use of a weapon, deadly weapon, in the commission of a crime. The commission of a crime against an older or vulnerable person, and a felony committed to promote the activities of a criminal gang can also result in enhanced penalties beyond the sentence that's imposed by the statutes for a particular crime. There are also offenses for which penalties increase based upon the number of reoffenses. So, for example, battery constituting domestic violence has certain levels of offenses: first offense, misdemeanor, second offense within 7 years. A third offense within 7 years can result in different penalties over and above just the battery with constituting domestic violence. A DUI first offense, as you all may know, is a misdemeanor. A second offense within 7 years equals a misdemeanor, and a third offense within 7 years is a category B felony. Now, the DUI area is also unique because the legislature has created a DUI court, which allows a defendant to avoid the consequences of their first offense by participating in a frankly lengthy and expensive, but I will add very successful DUI diversion program. And I congratulate the legislature who created the program and the courts who administer that program. It has been incredibly effective in our state. Then another example is unlawful operation of a recording device in a movie theater, which also can have gradations of offenses from misdemeanor up to a category D felony. We talked earlier about appeals and post-convictions in criminal cases. If a defendant pleads to a crime and is convicted, and there is a judgment of conviction and a sentence imposed, or a jury returns a verdict against the defendant and there is a conviction, the defendant has a right of a direct appeal to the Nevada Supreme Court, although that case could, depending upon the nature of the case, be pushed down by the Supreme Court to the Court of Appeals. The defendant also has the right for post-conviction review. Usually, those are thought of as issues raised by the defendant that raise questions concerning the ineffective assistance of their trial counsel. And that comes up fairly frequently. Once state habeas relief has been exhausted, the defendant may seek federal court post-conviction relief, raising federal issues. We talked about plea bargains. Just to reiterate, I stumbled through this, but I meant to include guilty, guilty by mentally ill, or nolo contendere. These are pleas that can be entered by the defendant. Of course, the district court is required to, as are justice courts, required to canvass the defendant, making certain that there is a knowing, voluntary, and intelligent waiver of all constitutional rights, and their acknowledgement that this plea is something that they voluntarily enter into. And the court must accept it. There are instances, although rare, where the court rejects the plea agreement depending upon the canvass that takes place and the circumstances of the case. Let's talk a little bit about bail. I understand that there are some measures that are coming before the legislature that address various aspects of bail. I prefer to refer to this topic as detention, pretrial detention. It is, to me, a much more appropriate descriptor of what we're addressing and a more appropriate descriptor of the constitutional status of the defendant when they are arrested of a crime. Keep in mind that simply because one has been arrested and probable cause has been found that the crime was committed and the defendant may have committed it, they are still not convicted. And as a consequence, they still possess certain rights to freedom that should be assessed and evaluated before they are ultimately convicted either through plea or through trial. I've listed on this slide certain information about bails, and I just want to touch on a few of these things generally to give you terms that you may hear about during the course of various hearings. The defendant must be admitted to bail under our Constitution and under a case called Valdez Jimenez that was decided last year, which I'll talk about in a moment, unless the charge is one of first-degree murder. This is true under our Constitution. Felony, parolee, probation, or arrests for a different offense must not be admitted to bail, and mandatory 12-hour holds exist in certain crime types like DUI, domestic violence, and so forth. We have heard about the use of bail schedules. Oftentimes, that has been a huge part of our system for many years, where dollar amounts were set by various townships and districts around the state that would set a bail amount for the defendant to pay in order to secure their release pending trial. Years ago, a committee of the Supreme Court called the Pretrial Release Committee studied this subject extensively. And what it found was that the bail schedules in Nevada varied substantially throughout the state by crime type and by dollar amount. There was gross inconsistencies between the amount of bail that a defendant who was arrested in one county would have to pay for the same crime charged in another county. As a consequence, the Pretrial Release Committee of the Supreme Court has made significant efforts to try to reduce the dependency of the use of bail schedules, and instead call for the use of bail hearings, individualized detention determinations based upon the defendant's criminal history, their ties to the community, and other topics that would assess whether or not the defendant should be continued to be detained. And as a result, the Supreme Court adopted the use of a pretrial risk assessment instrument that is now used throughout the state, where the defendant's risk assessment as a flight risk is assessed and provided to the judge as information to help guide the judge in their detention determinations. All that said, the work of the judicial system over the past several years, at least during the past 4 years at least, has resulted in a number of instances in which defendants with a first offense charge are fairly routinely released on the defendant's own recognizance. I mentioned Valdez Jimenez. I'm not going to quote this. That's a waste of your time. You all can read it. And I welcome you pulling up the case. It's a Nevada Supreme Court authored opinion where the subject of bail as a constitutional right for a defendant charged with a crime and an assessment of their detention status was set out. It is the first case in the state's history where significant jurisprudence outlined the conditions that are to be considered with respect to a defendant's detention status pre-trial. I'm sure you'll hear more about this case. I understand that a interim committee of the legislature has undertaken extensive work to study this case and this topic. And from that, I think there have been a number of recommendations that have been made for the legislature to consider embedding some of these provisions into the bail statutes. Misdemeanor citations are issued for minor offenses. Some of you may have received those and while driving inappropriately. Just as an aside, by the way, As if you were on a money committee, you would have heard me say to the money committees of the legislature that 34% of the Nevada Supreme Court's budget is funded through administrative assessments imposed on those who get traffic tickets. So we are put in the odd position of urging all of our citizens to commit traffic violations in order to provide enough money for the Supreme Court to operate. Now, if that sounds funny, it isn't. Does it sound foolish? It absolutely does. I have been on the Supreme Court now for 16 years. This is my 17th year. And I think every year that I've served on the Supreme Court, I've urged the legislature to stop funding the Supreme Court with the use of traffic ticket money. There is no correlation between the two, and it is a foolish thing to do. It also has horrific financial consequences for the Supreme Court to fulfill its obligations, its constitutional obligations, because what happens is when you have a pandemic, people aren't driving, tickets aren't being written, and the revenue, you're not talking about 12% budget cuts. We had a loss of 38% in administrative assessment revenue as a result of the pandemic. So the consequences are huge for this branch of government when that takes place. I'll get off my soapbox, sorry. I did want to reference one other area, and that has to do with competency. When an individual comes before the criminal justice system, we want to make sure constitutionally that they are competent to be able to understand the charges against them and competent to assist their counsel in their defense. Therefore, there are statutes that prescribe proceedings that allow for the assessment of a person who may be incompetent to participate in the proceeding appropriately. The court appoints 2 psychiatrists, 2 psychologists, or 1 psychiatrist and 1 psychologist to evaluate the competency of the defendant. These experts provide a report to the court to determine their competency. If the defendant is deemed incompetent, he or she must be committed to the state mental health facility for a determination of competency or whether they can attain competency. And sadly, in many instances, that does not always occur. A defendant must remain there until the court releases the individual, or the individual is deemed competent through subsequent evaluations and returned to the court to face charges. Lastly, the juvenile justice area. It is unique. And the state has undertaken, and the legislature has undertaken a lot of work in this area to make the process efficient and to more appropriately deal with children facing juvenile challenges. And so I just mentioned Title V of the Nevada Revised Statutes, which deal with children who are in the juvenile court system and how that process exists. There is a bill that is in front of the Senate currently, I understand, and if it's passed, will come over to you folks, that deals with the interplay of protection orders involving juveniles and how which court should handle those matters. Chair, I think that pretty much covers the overview. I'm sorry for the length. I hope it is helpful. And I just reiterate the willingness of the judicial branch to offer information, data, and testimony where appropriate to help your members understand or engage in these various issues.
Thank you so much, Justice Hardesty. Certainly appreciate the presentation. Members, particularly our non-attorney members, I know that's probably a lot to take in, but I would recommend that you save this presentation to your desktop because I think you'll be coming back to it on a regular basis. And of course, anyone who does not practice in court, is not familiar with court, feel free to ask one of the members that is. Some of this seems a little bit counterintuitive, but I think if we talk through it enough, we'll all be on the same page. Before we take questions, I did want to note for our the secretary that Assemblywoman Krasner and Assemblyman Miller are present. You can mark them as present. I think they arrived right as Justice Hardesty was beginning his presentation, but I didn't want to interrupt. So with that being said, let me go into gallery view here. I know I have a couple of questions so far, but are there other members who have questions? If you could raise your hand in front of your computer, and that way I can tell there are questions. So right now, let's start with Assemblyman Ohrenlicker.
Thank you, Chair. And thank you, Justice Hardesty. My question is about the enhancements where, oops, sorry. Let me see if I can get my video back.
Hello, Mr. Orentlicker. This is BPS.
Okay, you got
Your
it.
video is fine.
Okay, so on the enhancements where it's 1 to 20 years for the different triggers for enhancements, that seems like a lot of discretion. Are there other parts of the statute that narrow the discretion? And if not, have we looked at how this discretion is used to make sure it's not used that race or wealth or other inappropriate factors aren't influencing the application of that enhancement discretion?
Thank you for the question, Assemblyman. Nice to meet you. Couple of things I would mention. A lot of work has gone into the Nevada Sentencing Commission, and the legislature in enacting AB 236 also institutionalized the Nevada Sentencing Commission. I would commend to this committee in particular its review of 4 reports that have been sent to the legislature by the Nevada Sentencing Commission with respect to its work over the last biennium. That commission is charged with accumulating and evaluating data that we hope will answer questions like the ones you've asked. The statutes themselves provide that range, and that is generally a discretion exercised by the judge depending upon the facts of the case. And so we have urged the legislature to start making data-driven decisions based upon this kind of information, or this kind of question. So I would think that over the course of the next probably 2 to 4 years, legislators will be in a much better position than they ever have been by having data evaluations or data information from the Nevada Department of Corrections, the Nevada Division of Parole and Probation, and analyzed by the Sentencing Commission that can make recommendations to you to show diagrams and describe results and impacts associated with that kind of enhancement and how it's being used and arrived at. We've been flying blind in many of these areas, and that was a major motivator, I think, for many of the changes in AB 236 last session. I think it has also had some serious adverse fiscal consequences where you have a high number of people incarcerated for lengthy terms, which are not the same as maybe defendants who have engaged in the same conduct and are subject to the same enhancements. I hope that's helpful to your question.
Thank you.
Okay, do we have further questions from members? Did I see a show of hands? If anyone has one, let's go to Assemblywoman Summers Armstrong.
I'm unmuted. Good.
Assemblywoman Summers Armstrong, your audio is not coming in. If you could go to the bottom left corner where your microphone is and toggle between microphone and same as system, maybe that will work. All right, can you say something so we can check? Nope, I am unable to hear you again. Let's see.
Okay, well, here's what we'll do.
Chair-
in the interest of time-
Chair, if I could make an offer, I apologize for interrupting you, to the Assemblywoman and to the entire committee. If people have questions periodically, they're more than welcome to email the court, and we will do our best to provide information that answers a question for them.
Thank you, Justice Hardesty. I just mentioned that through the use of our chat feature, Assemblywoman Summers Armstrong had sent me the question she wanted to ask. So if you'll give me a second here, I'll find that and I'll ask the question.
Can you hear me?
Oh, we got you.
Okay.
Okay.
Thank you all so much for your patience. The tech gerbils are out this morning. I did have a question, Justice Hardesty. By the way, I really enjoyed your presentation. And I wanted to know if you all are collecting any quantitative data on, I know there's been some concerns about preemptions on juries. And have you all begun to collect any data to see if your efforts are ensuring that juries are more representative of the community?
Thank you for the question. Nice to meet you, Assemblywoman. No, the AOC has not undertaken that, but that is part of the effort that will be initiated by the court to determine how that's taking place. I have the privilege of presenting to the legislature the State of the Judiciary address on March 25th. And part of that address will include an initiative by me as chief to evaluate not only this topic, but other various aspects associated with racial equality in the judicial system and implied bias educational needs throughout the criminal justice and justice system. So I'm hoping that that initiative will start us on the path of developing data-driven decisions to examine those questions.
Thank you, sir.
Do we have other questions from members? Justice Hardesty, let me ask one quickly for the benefit of the committee, because I think we had this come up last session. The Supreme Court has a number of bill draft requests, and when those are put in, it says it was requested by the Supreme Court. But I understand there's a process where other courts of different jurisdictions can submit bill requests. If you could maybe just tell the committee about that and what your position is on whether the Nevada Supreme Court officially supports all of those bills as a court or whether it's something different.
Thank you for the question, Chair. The legislature has extended to the judicial branch the opportunity to submit a total of 10, not in excess of, but a total of 10 bill draft requests each session. I would argue that that is an understatement of the bills necessary to come from the judicial branch, but that's what we are allocated. When that was made known, we established prior to that, we'd established a Judicial Council. And the Judicial Council of the state includes representation from all of the courts, at least by area, throughout the state and all levels of courts. There is also a committee within the Judicial Council, the Legislative Committee, which is chaired by the Chief Justice. And that committee hears suggestions from the judiciary and court administrators throughout the state for potential bills. And as a result of that, we will then evaluate, prioritize, whittle down the suggestions that we receive from the various courts to the 10 bills that we have allocated to us. The Supreme Court has certain priorities that affect the entire judiciary. So, for example, we requested, again, a bill that addresses compensation of judges. The legislature did not take that topic up last session. We're hoping that it will consider taking that topic up this session, because if it even if it were to pass this reform measure, a measure that reforms the way in which district court judges are paid, the district court judges of this state will not have had a pay adjustment for 18 years. We think that that is problematic in our ability to attract qualified people to the court. That is an example of a bill, Chair. It's currently SB3, but it is an example of a bill that affects the entire system. But there are other bills that will come to you that are proposed for consideration by the limited jurisdiction courts only because it principally affects them. For example, a bill that addresses the towing of vehicles. And so just because these bills are passed on to the legislature, they do not bear the endorsement of the Supreme Court unless we appear and sponsor those bills directly.
Thank you, Justice Hardesty. I think that's helpful. And I'll remember to clarify that for the members when we hear some of those bills. I mean, we get bills from all different places, and sometimes there can be the suggestion that because the Nevada Supreme Court's name is on the bill as a requester, that's, supported by the court. But we'll remind folks that that's not always the case.
We're happy to distinguish those if that helps you.
Thank you, Justice. Any other questions for Justice Hardesty this morning? I don't see other questions. Justice Hardesty, I want to thank you for spending about an hour with us this morning. It's always a pleasure to have you in committee. I'm sure this is not the last time we'll be seeing you in committee, and members, I have found Justice Hardesty to be available and more than willing to help or answer questions. So please feel free to reach out to him after this presentation if you have questions, or if you're working on legislation that he might be able to offer some help with or some guidance. And Justice Hardesty, again, thank you so much and have a great rest of your day.
Hey, thank you very much for including me, Chair. I appreciate being asked to participate and join your committee today.
Okay, committee members, so we'll go ahead and close that agenda item, and we're going to move along to our next set of presentations. Committee members, you'll recall yesterday we heard from our district attorneys both in Clark County and Washoe County. Today we have their counterparts, so we have an overview of the Clark County and Washoe County offices of the public defender. And joining us, we have Mr. John Pirro from Clark County Public Defender's Office and Miss Kendra Birchie from the Washoe County Public Defender's Office. Much like I mentioned yesterday with Mr. Jones and Miss Noble, you're going to be seeing a lot of Mr. Pirro and Miss Birchie in our committee as we process criminal justice related bills. So I wanted to give them a chance to introduce themselves, give a brief overview of their respective offices, and then we'll have a chance for questions. So Mr. Pirro, Miss Birchie, welcome to the Assembly Judiciary Committee for the first time this session. And when you're ready, please go ahead and proceed with your presentation.
Thank you, Chairman. I'll just start off if that's okay. And we'll do the screen share. I wanted to talk to the committee about public defense in Las Vegas. It is our biggest jurisdiction, and we consider it to be the gold standard of public defense here in the state. What happens in Vegas, though, doesn't always stay in Vegas. As you all know, our Las Vegas Convention and Visitors Authority tends to talk about this slogan. However, a less catchier slogan may be "come here on vacation, leave on probation," not as big of a seller. The quote that I have up here is by Mr. Niebauer: "Love is the motive, but justice is the instrument." And this is our guiding premise in the work that we do. We consider ourselves your community lawyers. 85% of our community cannot afford a lawyer. So we are the first line of defense. We represent your mothers, fathers, sisters, brothers, and cousins when they are accused of a crime. And as many of you know, and Prison Director Mr. Daniel spoke about, there are a lot of moms in prison. And prior to the passage of AB 236, Nevada was headed down a very negative trend of incarcerating more women than our other states, with a third of those women having mental illness. We took steps last session with AB 236's passage. Thank you to the chairman in this committee. And we hope to continue that trend and moving in the proper direction. We consider ourselves to be problem solvers and grace givers. All justice should be tempered with mercy. Dr. Cornel West says justice is love in public, and that is what we do every day in our jobs. Before we get too far, Kendra and I picked up some new interns working from home. They're more interested in eating bills than reading bills. So if I say that the dog ate my homework, I definitely mean it. And they may bark to let you know how they feel. I want to talk to you a little bit about the advent of public defense, but I won't spend too much time on it because Ms. Birchie will cover this as well. The case that created our jobs is Gideon V Ray Wainwright. That is Mr. Wainwright, Mr. Gideon. He petitioned the Supreme Court by himself for a lawyer. He was convicted in Florida, and the case went all the way to the United States Supreme Court. He was appointed a lawyer, Abe Fortas. He won the case. The case was remanded back down to the Florida court. Mr. Fortas represented him there, and the verdict was not guilty on retrial when he had a lawyer. So it's important that there are skilled lawyers on both sides of the case. I want to talk to you all about some celebrity public defenders, starting with the Senator Richard Bryan. He was the very first public defender in Clark County, and Clark County was on the cutting edge of, after that Gideon V. Wainwright decision, in implementing public defense. We have Assemblywoman Nguyen, that's her picture from last session. I apologize for not grabbing the most current one. Senator Arnshaw, and as you know, the chairman and the speaker. I do want to make the plea that I make to our legislators up north every session. There's a statue of Richard Bryan at the University of Nevada Reno campus. It has benches all around it so students can sit down with his achievements and public offices that he held. However, one bench is missing, and that is his achievement of being the first Clark County public defender. And now I want to talk to you a little bit about our office and numbers. We have 121 lawyers, and that could be plus or minus. We won a lot of elections this year, and a lot of our lawyers transitioned to the bench. We are broken up into teams, and that's for a good reason. If any of you don't know, we have our own Miranda case. So not the you have the right to remain silent case, but Roberto Miranda, when Clark County was sued for $5 million because brand new lawyers were representing people accused of murder, and they just didn't have the skills, and it resulted in some bad results, would be the best way to put it. So we're broken up into teams. We have attorneys that specialize in juvenile defense. We have an appellate team, attorneys that focus in the defense of sexual assault and murder, the track attorneys, of which I am one, where we handle everything else under the sun, our mental health team, where if you look at the 2019 numbers, I'm sorry that we don't have the 2020 numbers yet, they not only participate in all of our specialty courts representing people who are in the mental health court system or other drug court and co-occurring court, but they also handle the civil commitments, and that you can see is plus or minus 3,500 commitments in 2019. We have a serious mental health crisis down south and all over the state, to be quite honest. In 2020, we had less cases filed, but I do want to make this committee aware that there is a huge backlog. When COVID started, the DAs held back about 5,000 cases, and then when we went on pause again, there's another backlog. So we have been getting crushed and will continue to get crushed as those backlogs come into the system. We also try to practice somewhat of a holistic defense model where we have 7 social workers, investigators, and mitigation specialists to help us in our cases. I always call our social workers doing God's work because they help us get our clients into specialty courts and take care of things. Another thing I want to make this committee aware of is that we have an immigration advisor on staff, and we also speak with Professor Kagan regularly because when you are in the criminal justice system, it can affect your immigration status. And one of the most severe penalties that can occur is deportation. There is nothing worse than representing a client who is convicted of a crime, and had he been a citizen of the United States, would have went to prison, served his time, and possibly came out and been a productive member of society. But because of the conviction, may now be deported to a country that they have never known, that they haven't been in since birth, that they have no family ties in anymore. And that is one of the scariest things that we handle in our job. Another thing that's unique to Las Vegas is tourism. And Director Calloway spoke about that. We have about, on a good year, 42 million visitors, which adds to our caseloads here. Because what happens in Vegas doesn't always stay in Vegas. The other thing that I wanted to talk about, and I'm glad you brought that up, Assemblyman Orrin Lichter, is that we really have just started studying data, and it's important that we continue to study data because, as Justice Hardesty said, we've been kind of flying blind. And if I can tag on that, Justice Hardesty talked about the death penalty a little bit, and I do want to bring this up. Bryan Stevenson, the founder of Equal Justice Initiative, has talked about the death penalty across America and its shocking rate of errors. Nearly 1 in 10 cases are overturned because of an error in the court process or the person was innocent. And that is a shocking rate of error. I know I wouldn't get on a flight to Reno. I'd drive every time for session if I knew that 1 in 10 flights were going to crash. I want to talk about also what we do. We generally carry out the intent of our founders because liberty can't be taken without due process. America's system is #1 in the world considered for the judicial system, but I can also inform this committee that we are also #1 in the developed world for incarceration of our citizens and people on supervision. And as Justice Hardesty has stated, we kind of have become a plea factory rather than a trial system. It's very important. Last session, when we were able to do things together, there was a very famous play, Hamilton. Now we only can watch that on Disney Plus right now. However, Alexander Hamilton was a defense attorney. John Adams, defense attorney. And so it's important that you have a defense attorney to step into the gap when fear and emotions are running high, because we can only work on being the best when we properly preserve due process and make sure that the constitutional rights that soldiers fought for, our fellow countrymen fought for, and our founders fought for cannot be overran because we don't like the slow process of justice. I also want to talk about trauma-informed care. And I thought this picture was pretty relevant because we deal oftentimes with broken people in a broken system. And as Maya Angelou has said, do the best you can until you know better. And then when you know better, do better. And originally, the question and the system used to ask is, and frankly still does ask, why did you do what you did? However, trauma-informed care has shown us that the proper question is what happened to you in your past that brought you here today? The system only sees a crime, but we as public defenders see a whole life. And if I could impart a short story on what a whole life looks like, sort of. I recently had a trial with a client that was homeless, and we obtained a not guilty verdict in that trial. And when the jury was announcing that verdict, I was elated that my client was not going to be convicted. And I turned to him and I said, and I'm not going to use his real name, Mr. Smith, you get to go. And I had to stop because I wanted to say the word home, but he didn't have a home to go to. I knew that he was going to get released from the jail at 2 a.m. and he was going to be back in the same crummy situation that he was before we took this case to trial. And that type of stuff we see all the time. And those are the little things that break your heart. And you know that the system needs improvement. I also want to talk about holistic defense, and Ms. Birchie's going to talk about this as well. I'm going to start with the bottom part, which is the RAND Corporation study. As all of you know, the RAND Corporation isn't some liberal think tank, and they do in-depth studies on issues all over the nation. One of the things that they studied was holistic defense, and they compared the Bronx defenders, which is the gold standard of public defense, to legal aid, which is another public defender agency in New York in the Bronx, which is more traditional like our office is. And what they found after studying almost a little over 500,000 cases is that true holistic defense obtains better results, less time in jail for the clients, which saves the taxpayers money. As Director Delap may explain to you, a day in the Clark County Detention Center costs us as taxpayers $170 to $190 a day. And every year in the Nevada Department of Corrections costs us as taxpayers up to $25,000 or more. They also get better results in recidivism and better results for the community. And when I say holistic defense, they have housing lawyers on staff, family lawyers on staff, landlord and tenant lawyers on staff, and social workers on staff, as well as immigration attorneys on staff, so that they really can take into account the whole person's life and try to fix the things that we can. We're all trying to work toward a model of holistic defense here, both in Clark and Washoe County, but we have a long way to go. And part of what we do is we work with our partners in the community down south, and it's the hope that these type of committees start all over the state. We have the Criminal Justice Coordinating Committee, where we work together with the sheriff, the jail, the DAs, and other community partners to put better solutions into place. And one of the things that we accomplished here in Clark County was creating the initial arraignment court, which allows a person who is arrested to be seen within 12 to 24 hours of arrest to see if they can be released. That helps clear up some of the space in the jail, but also clears up some of the space in the court and creates better results for clients. Our goal as public defenders is to never see another client in County Blues again. Once we meet you, we want to work to get you out of the system and never back into the system. If I worked myself out of a job, I would be more than happy to leave. I love my job, but it'd be better if I didn't have to do my job. We also stand with the demonized so that the demonizing will stop. We stand with the disposable so that hopefully the day will come when we stop throwing people away. We stand with those whose dignity has been denied and their burdens too much to bear, and we help to shoulder the load. And we stand with the poor, the powerless, and the voiceless, and we do our best to make those voices heard in a system, because you have to transform pain, because if it's not transformed, it will just keep being transmitted. As my friend John Ponder from Hope for Prisoners like to say, healed people heal other people, but hurt people hurt people. And so we work towards redemption. I skipped a little bit in my slide ahead, but Justice Hardesty and John Jones went over this. What we'll say is we have a vertical model of representation. So if I start as your lawyer, I'm your lawyer from the initial arraignment all the way through the end of your case, and I'll be there for you step by step. The only thing I do want to talk about here in this slide is the Valdez Jimenez decision. You are going to have an issue that comes before you, and it's the meaning of the word prompt, which is that case left undecided. And part of the problem with the meaning of the word prompt is it's being interpreted differently all over the state. As I've explained in the initial arraignment court in Las Vegas Justice Court, if you are arrested, you will see a judge within 12 to 24 hours to see if you're eligible for release. But if you're on the wrong side of the street and you pick up a crime in Las Vegas Municipal Court, you may not see a judge for 3 to 5 days. In Henderson, you may not see a judge for 3 to 5 days. In North Las Vegas, you may not see a judge for 3 to 5 days. And I think my Southern legislators would agree with me that Henderson and North Las Vegas are not rural counties. But I don't want to discount what happens in rural counties, because the justice you get in Clark County should not be different from the justice that you get in Hawthorne or Lyon County or in Carson City or anywhere else across this whole state. Prompt means prompt. And so we have to work on this issue because people should not be getting different types of justice just because where they live in this state. Here's what we don't do. We're not a get out of jail free card kind of attorney. We work on things. If you've done something and there are consequences attached to what you've done, well, there's going to be consequences and you may have to serve time. But what we try to do is make sure that everybody is looked at individually on a case-by-case basis, and we try to find the right solutions for our clients so that they're never back in the system again. There are some challenges facing our offices. We have high caseloads. I would go so far as to say overflowing caseloads. As some of you know, and probably why you ran, we have a lack of community resources, both in pre and post accusation. And what I mean by that is, if you are poor here in the state of Nevada, it is easier for you to get services once you are accused of a crime than it is before you are accused of a crime. And the criminal justice system is a very expensive place to solve problems. A lot of times when I have clients, I am the first person to recognize that there is a mental health issue and the first person to send them to a doctor to get a diagnosis. That's very difficult for both our police officers dealing with mentally ill people on the street, for us in the system dealing with it. And if we put more resources on the front end, perhaps we would have to spend less on the back end here in the criminal justice system. Our jails and prisons have become the mental health warehouses of our state. As I explained earlier, 1/3 of women in prison have mental health issues. And in the jail, almost 1/3 or more of the people in jail are on some form of psychotropic medication. It's really stressing the system because mental illness is a flaw in chemistry, not a flaw in character. AB 236 helped us take some steps in the right direction, and we're hoping that we can continue to move forward in that direction. I also want to talk about us being on the front line because we cannot incarcerate our way out of our community's challenges. And you'll hear a lot probably about sex trafficking here throughout this session. And I want to say that oftentimes we are also the first people to recognize a victim of sex trafficking because their crimes are not as cut and dry as solicitation, but sometimes they are forced by their pimps into more difficult situations. And I want to relay a story about, again, Mrs. Smith. I'm not going to use her real name for her protection, but she gave me permission to use her story. 2 years ago, we represented Mrs. Smith. She came from a state down south, and she wasn't really wise to the big city. The people that brought her out here said, hey, there's money to be made and jobs to be made with our economy at that time. And when she got here with her 1-year-old son, they said, no, those aren't the type of jobs we wanted to give you. That's slow money. We want you to make fast money. And so this gentleman broke into cars, stole people's credit cards, and then forced Mrs. Smith to go into the store and use these credit cards. So her crime was not traditionally on the radar of a victim of sex trafficking. And we brought that both to the police's attention and to the district attorney's attention. And instead of dismissing her cases, they made her plead to misdemeanors. And so now I'm in the process of working on sealing both her misdemeanor record so that she can get a better job. But also, it was very difficult to even get the district attorney, and he was a district attorney who I consider a great district attorney, down to just misdemeanors. So these are some of the difficulties we have in this system. It's a tremendous amount of work to reform the system, but I think if we all keep chipping away at this rock, eventually we'll get to where we need to be. Moving forward, I think we're going to need more resources for rehabilitation, both drug and mental health treatment before a citizen enters the criminal justice system. A lot of the treatment before you are accused of a crime or even convicted of a crime relies on insurance. And if you're poor, you don't generally have insurance. And especially looking at everybody who has lost their jobs throughout this COVID pandemic, the lack of insurance and the insured has grown even bigger. But the goal is to catch people before they're victimized or victimize others. We also want to work on sealing records. Justice Hardesty talked about the DUI program and its success. And in 2017, we passed, your body passed, a big legislative record sealing bill, which was great. It changed the system from what it was to what it is now, but there is still work to do on the sealing records problem. And I can even relay that for Mrs. Smith as well. It needs to be more streamlined, made a little bit simpler, and perhaps provide more relief for some people who didn't have relief in the past. And we're going to have to work together on these. We can't solve these problems at arm's length using fear and anger to separate ourselves. I think Mother Teresa's advice is prudent here. The problem is that we have forgotten that we belong to each other. If kinship is our goal, then we wouldn't be fighting so hard for justice. We'd already be celebrating it. And with that, I'll leave myself open to questions after Ms. Birchie's presentation or however the chair wishes to proceed.
Thank you so much, Mr. Pirro. I'll have to let my mother know that I've made it official as a celebrity. She'll be happy to know that. And of course, she's probably going to ask me why I don't send money. So I'm going to leave that question to you. But thank you for your presentation. We're going to go next to Ms. Birchie, and we'll hear her presentation, committee, and then we'll have a chance to ask some questions. So Ms. Birchie, welcome to the committee. Please go ahead.
Good morning. Thank you, Chair Yeager and members of the Assembly Judiciary. Thank you so much for inviting us to present today. As you heard, we will be presenting or testifying very frequently in this committee because a lot of the hard work that you'll be working on with the bills and legislation will not only impact our office, the way that we practice law, but more importantly, will impact the individuals of our community. Just by way of introduction for those who do not know me, as you heard, my name is Kendra Birchie. I am a felony criminal defense attorney with the Washoe County Public Defender's Office. I've been with the office for the past 5 years. This is my second session, so thank you again for having me back. And I'm currently on our Category A team, which I deal primarily with individuals who are accused of murders and sexual assault charges. But that's enough about me. So let's talk about, as you heard, Mr. Pirro mentioned, one of the biggest cases that involves the Public Defender's Office is Gideon versus Wainwright from 1963. So as we all know, the Sixth Amendment does state that in all criminal prosecutions, the accused shall have the right of counsel for his defense. But it wasn't until this case, not until Clarence Gideon argued that this should ensure that state courts should require a lawyer for not just capital penalties, but for other cases as well. As Mr. Pirro indicated, this is a really interesting case because of just the unlikely hero that Gideon was and the large impact that this has had on criminal defense cases. As stated by Attorney General Robert Kennedy, if an obscure Florida convict named Clarence Earl Gideon had not sat down in his prison cell with a pencil and paper to write a letter to the Supreme Court, and if the court had not taken the trouble to look for merit in that one crude petition, the vast machinery of American law would have gone on functioning undisturbed. But Gideon did write that letter. The court did look into his case, and the whole course of American legal history has been changed. So since that case, there have been additional cases which ensured that individuals who are accused of crimes have the ability and the right to have an attorney, and not just felony cases, but also misdemeanors, as long as there's a possibility of imprisonment. The Washoe County Public Defender's Office is a creation of both state and county legislation. And that's our lovely logo there. And our mission statement of the Washoe County Public Defender's Office is to protect and defend the rights of indigent people in Washoe County by providing them access to justice through professional legal representation. And so to go with that, our vision statement is in threefold: advocacy, integrity, and community. And as Mr. Pirro indicated, that community is really that we are the community lawyers. More importantly, not only do we advocate for the regular members of our society, mothers, fathers, daughters, but we also engage in a lot of community service activity. That's something that is really important to our office, to make sure that we are engaged and productive members of our community, not just in terms of being in the workforce, but really understanding the needs and assist to address those. So what do we do as the Washoe County Public Defender's Office? As you heard Mr. Pirro indicate, he went through the specific different types of courts that we appear in terms of working on juvenile cases, criminal cases, probation, revocation hearings, parole hearings. We also have an appellate division. We also represent individuals who are involved in involuntary commitment hearings. So when they're suffering a mental health crisis and a hospital or a physician or their families trying to petition to have them remain there, then we represent those individuals to ensure that their due process rights are being maintained. The main difference between our office and Clark County is that we also have a family division, so that we represent parents who are involved in that foster care system or the dependency system. So here's just a little slide so you can see all the different places that we go to, all the different courts. We've got in Reno, Sparks, Incline, the appellate court in Carson City, as well as Wadsworth. As Frederick Douglass said, where justice is denied, where poverty is enforced, where ignorance prevails, and where any one class is made to feel that society is an organized conspiracy to oppress, rob, and degrade them, neither persons nor property will be safe. And that's why we practice what's called the holistic defense. As Mr. Pirro indicated, we really work on not just who that individual, that crime that they're charged with, but really focus more on getting to know that client, getting to find out what services are needed, and to implement life changes to help prevent recidivism. By addressing what are often the core common issues impacting our clients, poverty, mental health issues, and addiction, we hopefully make life-lasting changes. It's a philosophy and vision that looks beyond the immediate client and their charges to the protection and validation of their fundamental human dignity and quality of life for their client, their families, and our community. So I found what I think is a really good representation from the Quadrant Center for the Fair Administration of Justice at Penn Law. And they provided me with permission to use this to really explain kind of how everything in the traditional indigent defense model is really just funneled through the attorney, and it's up to the attorney to find out what resources are available. And the holistic defense is really having all those resources available for use by the client, where we're able to have, in essence, a one-stop shop to provide all that information and those services to the client. And why that's important is, as Mr. Pirro mentioned, is that sometimes our clients, their first indication that, you know, they're willing to come forward as that victim, or they're willing to start engaging in services or know how to engage in those services, is when they're involved in the criminal justice system. Just to give you some of the statistics from the RAND study that Mr. Pirro mentioned, is that just having this holistic defense and representation reduces the likelihood of custodial sentence by 16%. It reduces the expected sentence length by 24%. And over a 10-year study, this holistic representation in the Bronx resulted in 1.1 million fewer days of incarceration which saved the New York's taxpayers an estimated of $160 million on inmate housing costs alone. So besides being an advocate for someone in court, a zealous advocate, a voice for the voiceless, here are some of the other things that we do. Sponsors, cheerleaders, role model, counselor, financial advisor, travel agent, housing locator, technical support. That's been very big during this pandemic where we have to teach people how to use Zoom, dog foster, DMV expert, mentor, and it just keeps going on and on. So I think this really shows how much we have to be involved in order to enact change with our clients. When we first started as an office in 1969 after Gideon, we had 3 attorneys. Our support staff included 3 support staff members and 1 investigator. Now, we are 37 attorneys strong. We were able to hire 1 more attorney in the interim session, so we're very excited about that. We also have an immigration attorney on staff who assists with ensuring that we comply with Padilla and are able to provide our clients with the most recent information on immigration consequences, since, as I'm sure you all have seen in the news, that is something that is constantly changing, and so it's really important to have someone on staff. As I indicated, we have attorneys and we specialize in groups. So I'm on the Category A felony team. I was a track attorney on the felony team. We have a specific team who is the misdemeanor team. Those are the individuals who primarily handle our pre-detention hearings, our bail hearings, the 72-hour hearings, but the felony attorneys assist on that as well. We have the juvenile team, family law team, mental health, hospitalization team, and we do not have social workers on staff, but we do have a really great program with the University of Nevada, Reno, where we do have a social work interns. Luckily, even though during COVID, their program changed, we were able to keep having social work interns, and we currently have several on this semester, and we're very grateful for them. One of the members of the ACLU, Nick Shepak, was one of our interns and did a fantastic job for our clients. We also have a mitigation specialist, and that's something that's unique to some public defenders' offices, and I will absolutely not do her justice in saying what she does, but the basics of she's able to provide support with additional research, with reaching out to family, with reaching out to different organizations to ensure that we have what we need in order to start working on the case, to prepare for trial, and more importantly, to prepare for sentencing if there is one. We also have a summer legal intern option. Due to COVID, again, that's changed. We're hoping to continue to have legal interns since they are absolutely invaluable to our cases. So now for criminal justice trends. I'll start with just 2018. I'll go through these pretty quickly just because you do have this provided to you where it just provides the breakdown of the cases we've received, the breakdown between the different divisions. In 2019, it really didn't change too much in terms of the breakdown. I would just note that in the section for appeals, paroles, and miscellaneous, this does include also the cases where we're appointed because an individual is now able to have, thanks to the work that was done last session, to have counsel if they are picked up on a material witness warrant to ensure that they do have counsel to discuss that issue with them. Then in 2020, obviously COVID happened. We did have less cases that we received. I'll echo just the statements that Mr. Pirro made. But as you know, it doesn't really change the amount of hospitalizations or anything like that. So those cases still continued. Here's a great graph that we'll be able to provide next session for all of the years due to the new program that we have, which breaks down for each month. So you can see, obviously, in March, we did have a dramatic decrease in the cases that we received. And this is for felony and gross misdemeanors as well as misdemeanor cases. Then here's a breakdown for the different divisions, just for another way for people to be able to see the breakdown of who does what and how many cases we received and when. And as you can see, even in March, there really wasn't a difference for family law cases, juvenile cases, civil commitments, and appeals. Here's just to show if, for example, there are 2 individuals accused of a crime in one case, our office can only represent one of the individuals, and so we will conflict off of the other case. That will go to the alternate public defender's office. If they can't keep it, it'll go to our conflict panel. But here's just a graph to show how many cases we do keep, we retain, versus that we conflict off of. Before I go on to this slide, I do just want to state, I don't have the numbers for this year, but just to give some perspective, in 2019, we conducted over 43,000 court appearances on behalf of persons by our office. You heard a lot about the adult criminal process from the Supreme Court Justice Hardesty, as well as from the District Attorney's Office. So I won't go into it too much. I would just note that what I have here in misdemeanors through pretrial, we call it the mandatory status or mandatory pretrial conference for felonies. That it's a mandatory status conference. That's unique to our system. It's not practiced in Clark County. It's a separate hearing where the whole purpose was to have people come to court to ensure that we are all together, the district attorneys, the defense attorneys, to try to resolve cases, to figure out what the next steps would be if we're going to preliminary hearing, if we're going to trial, if we're able to try to resolve the cases. So it was another hearing, another option to have before the requirement of everyone coming on a subpoena and potentially having resolved the case instead of going to trial. Due to COVID, we have not had those hearings. It's just done by phone call. I would note that in Incline, they are accommodating this, the MPs, the mandatory pretrial conferences by Zoom, where they're sending us into breakout rooms. So we are working on different ways to ensure that this is available. Just to note, currently, the average felony attorney has approximately 75 to 90 open cases. The average misdemeanor attorney has around 160 cases open at one time. So that's not for the entire year. It's if I looked into my my calendar right now in terms of all the cases that I have, that's what would show up. So I have it broken down here for the gross misdemeanor felony, just to kind of give a little overview of this system. As you heard, Valdez Jimenez greatly changed the way that we do pretrial detention hearings. I did provide in the materials the Valdez Jimenez case. So if you're interested in reading what that is, that should be located there as well. I also provided a Nevada Lawyer magazine article that was written by John Pirro, which really explains this case because it is complicated and has so much of an impact. We thought that was important. But basically, the goals of Valdez Jimenez is to ensure that someone who's accused of a crime is afforded the same protections, equal protection under the law, no matter where they're located. It's to create a fair and just system. So just to go over kind of the basics of what happens is when someone's arrested and they first go to, in Washoe County, the detention facility at Parr Boulevard, they meet with individuals the staff members, to be medically cleared. They are then provided with paperwork in order to have a public defender appointed to them. And they also meet with someone from pretrial services to fill out what is called the NPRA, or the Nevada Pretrial Risk Assessment. And that form is what's then provided to the judge for the judge to do an initial review hearing. You'll hear more about that NPRA in terms of just some of the concerns that there are regarding racial bias, as well as potential bills in order to make sure that we're actually tracking the system to ensure that it's working correctly and that that system is evidence-based, since it is going to the judge and they are making a determination as to whether or not someone should be released after reviewing that NPRA and what's called the probable cause sheet, which is the initial report that a officer will fill out after someone's been arrested. So that's the judicial review is done not in a courtroom. A judge reviews that without input from public defenders or district attorneys in order to determine the initial bail amount. Again, we don't have a bail schedule, so it's really up to the judge to make that decision. And that's when they also decide whether or not to just issue what's called a no bail hold, where that person would not be able to post bail until that first appearance court. In Washoe County, there's differences between on what court you're in. In Reno Justice Court, you're going to have your bail hearing that next business day at what's called the first appearance docket. In Sparks Justice Court, that's going to be approximately the third business day after your arrest. It's called a 72-hour hearing. That's where we're able to request for a person's release. I would just note that this is that third business day was kind of due to negotiations as well. There was some original talk that that third business day hearing was actually going to be at the mandatory pretrial conference or status conference, which happens 14 days after the first appearance. And I'll just note that the district attorney's office agreed with us, and they did work in order to ensure that we were able to have bail hearings prior to the 14 days after the first appearance. We don't represent individuals in municipal court, but just for information as to why this is such an important issue on the timing, I am aware of cases where we've had college students who have no criminal history in municipal court, so for misdemeanor charges, who are held on a no bail hold for 4 days. So that's kind of why this is such an important issue, especially because there's no standard of when exactly these hearings are taking place. So it's hard for us to be able to tell clients exactly when they're going to have the hearing. We're working on making sure that that's very clear, as well as trying to figure out how clients can even be informed of what their bail is prior to that hearing. When the judge does the review and set the bail amount, we don't have an opportunity at that time to speak with our clients, and nobody tells them what that bail amount is. Their family members have to figure out how to navigate the system quick early on in order to see what's going on and what they can do. As I indicated, we have a designated team to represent individuals. We changed this after the Valdez Jimenez decision in order to try to ensure that we're providing representation to our clients as quickly as possible. What this means is we have a misdemeanor and a felony attorney every morning in court representing these individuals in Reno Justice Court, as well as an investigator who is reaching out to try to confirm housing situation, employment, things like that, as well as a secretary. We have to have a secretary because in Washoe County, the district attorneys are unable to, as Ms. Noble indicated, email us criminal history sheets. So we have to send a secretary to walk to the district attorney's office to pick up the criminal histories, to sign for each and every single one, to then come back to our office to upload it and to ensure that the attorney handling the case has the information. I would note that if anyone's interested in watching these bail hearings, please let me know. They are online. I think Friday you may have some availability. So please reach out to me and I'm happy to send you to the specific YouTube links to ensure that you're able to watch it. So as we indicated, we do have some unique features. Since I went over them before, I won't go over them too much. Just part of what we do is also to ensure that our clients understand what their collateral consequences are of if they are convicted of anything. Sorry, I just want to note also, going back to the bail hearing, if someone is granted known recognizance release, that doesn't mean that they're released right away. They still have to go to the booking process where they are then released, and it can take several hours. Oftentimes at that point, depending on, even if it's just the next business day, their phone could be dead, and they're released up at Parr Boulevard, which has a bus stop that isn't always open. It's not in the best neighborhoods. And so that's just something I do want to note of. There are some issues just also regarding the timing of release. I'm sure that Lieutenant Solferino will provide additional information about the new Washoe County Detention Service Unit. I do want to give a shout out just to Detective Mark Hester, who's really gone above and beyond to ensure that our mental health clients do have transportation arranged so that we can hopefully, if they are released, provide them direct transportation to different facilities such as WellCare or any other appointments like that. So what's new, as you've heard, COVID obviously has been a huge impact on our office. We've been working with stakeholders to figure out creative ways to continue to hear cases. Zoom hearings have been new. We've had to learn how to use this technology. More importantly, we've had to teach our clients how to use this technology, which at times can be extremely difficult. I had a client where we spent almost approximately 2 weeks trying to figure out how he could use Zoom. And despite not having the appropriate equipment, not having a smartphone, and being housing insecure, we were able to make it work. So those are just some new additions that have caused some hiccups in the system. We do have a lot of new procedures in terms of we were able to hear 3 jury trials before we were shut down in November. The courtroom has been retrofitted to have plexiglass between clients, counsel, jurors. As Ms. Noble mentioned, we have a headset in order to speak with the court. We also have a separate headset in order to speak with our client. So it makes it very difficult when you're in a hearing to try to navigate to make sure that you have the right headset and are talking to the right person. More importantly, we've changed to have a shared drive because our court decided, and I believe the stakeholders indicated that due to the virus, we were concerned with passing documents. So we're using that in order to, and had to reinvent how you introduce evidence, as well as how to impeach different people. So just simple things like that, which are the bread and butter of a trial that we've had to reinvent how to do it in order to accommodate these unique circumstances. We also just started our criminal settlement conferences. I know that Clark County was utilizing that earlier. I believe that we had our first one during COVID. And so that is something that we're trying to utilize as well in order to resolve cases. But again, that's only if that's what our client wishes to do. Our office also went paperless due to COVID. We've luckily have been having a lot of different ways of communicating with our clients. The Washoe County Sheriff's Office did implement what's called jail ATM. It's an email system, which allows our clients to email us free of charge, which makes it a lot easier in order to be able to have effective communication, especially when our clients are placed on quarantine, if there are allegations that anybody else in their unit has been exposed to COVID. So that is a good way to be able to keep in contact with their clients. Additionally, we are utilizing what's called evidence.com. It's a cloud-based digital evidence management system that allows police departments to upload the video evidence captured by their body cameras. So what happens is a police officer uploads the body camera footage, and then the district attorney has to release it to our office. We are still experiencing some delays in terms of obtaining the body camera footage. And of course, this can only be done if an officer remembers to turn on to tap to turn on his body camera. We also implemented and started a social justice committee within our office due to the death of George Floyd and in the wake of the protests and what we've been seeing in our own community. We're really working on our office to ensure that we're providing community members with the ability to receive equal justice by ensuring that we are trained as best as possible. We are reaching out to different stakeholders in order to have workshops. For example, we continue to have workshops with national experts on race regarding implicit bias and training and how to utilize that training in the justice system when speaking to different partners, including with judges, to help everyone understand the issues that are in our system. We've also that's being done voluntarily. That's not for CLE credits. We also work on what's called CLE, so continuing legal education, where we work to provide our attorneys in-house trainings. We also provide those trainings for members of the defense bar, whether or not they work for a public defender's agency. We also participate in the sheriff's very first community resource fair. So we're working to ensure that we are active and out in the community. So with what's new, as we heard a lot from Justice Hardesty about AB 236, I won't go into that except really just thanking this committee for the hard work on that, especially Chairman Yeager, Vice Chair Nguyen, and obviously Supreme Court Justice Hardesty as well. Not only did it reinvent the penalty phases, as Justice Hardesty mentioned, but especially the Veterans Court and specialty courts programs. So with that, I'll just note that we've had several individuals who found this to be extremely successful. And I do appreciate the work that was done. And I do have a client who just wished to indicate that because of these programs, he was able to reunify with his family. And so he just really asked me to express our thanks to this committee for the hard work. We've already gone over the other issues. So as I indicated, you can see everything online for our different court proceedings. Feel free to reach out to me if you would like to observe any hearings. As Mr. Pirro indicated, we do have and with the lovely Zoom hearings, you'll likely hear my dog Molly. So just wanted to provide the court with, or not the court with, you guys with at least some visuals of my lovely sidekick during this session. So just to end, I think this quote really expresses what it is like to be a public defender. It's not an easy occupation, especially during these times of COVID. So public defenders stand alone, armed only with their wits, training, and dedication. Inspired by their clients' hope, faith, and trust, they are warriors and Valkyries of those desperately in need of a champion. Public defenders, by protecting the downtrodden and poor, shield against infringement of our protections, and in reality, protect us all. Thank you so much for listening to this presentation, and I look forward to working with the committee and ensuring that we protect the rights of our fellow Nevadans.
Thank you so much, Ms. Birchie, and certainly understandable that we may have some pets in the background. That's perfectly fine. I would just ask make sure members no cat filters on your Zoom when you log in. That would be helpful to not have that happen. And if you haven't seen that video yet, you should watch it because it'll definitely make you laugh. So here's what's kind of going on, committee. We have just a little bit of time for questions. I'm sure we're not going to have time for all the questions because we need to make sure we have time to hear our bill. So what I'm going to do is I'm going to recognize 2 of our members to ask questions. And then unfortunately for the rest of you, if you have questions, you're going to have to ask them offline. But I assure you that both Mr. Pirro and Ms. Birchie are accessible and responsive. So we'll take questions first from Assemblywoman Summers Armstrong and then Assemblywoman Hanson.
Thank you, Chair Yeager. Thank you, Mr. Pirro. And I'm sorry, I can't see her name. Ms. Bursky, for your time and your presentations, we appreciate it. Quick question about record sealing. One of the things that I've been concerned about is whether or not any of the folks who have requested their records to be sealed, one, are running into issues with compliance from the district attorney's office, who I believe has a part in this. And second, if you've all been able to assemble any data as to whether or not people who have had their records sealed are finding that background checks are still finding their criminal records because of the availability of information on the internet. Thank you.
John Pirro for the record. I would say sometimes there is a roadblock with the district attorney's office. And if that's the case, we can bring it before the court to sort that out. But it is it's up to the judge's discretion. And so we've had some difficulties with that. There was a recent Nevada Supreme Court case, though, that recognized that this body had passed legislation in 2017 that stated it is, I don't want to misstate it, but it's the goal to seal records once somebody files it. Like, there's a presumption that a person has changed and the record should be sealed. The second thing that I would say is the second part of your question, Assemblywoman, would be better directed at Nevada Legal Services to see if they've been keeping the data. I apologize, but our state and even my office has not been doing a good job of keeping data, and that's probably something we should be tracking.
Thank you.
Okay, so we'll go next to Assemblywoman Hanson.
Thank you, Chair, and good morning, Ms. Birchie and Mr. Pirro. It's good to see you, and always enjoy hearing from you, and really do appreciate the vital lifeline that public defenders are to the system. I've told you before, I'm the daughter of a district attorney, but I have a great appreciation and respect that we need public defenders, and it's that tension between the two sides of defense and prosecution that hopefully get us to where justice is. With that little disclaimer, I've been concerned, I'm sure you have too, with COVID and the impact this has on the Sixth Amendment right of defendants to have a speedy trial. And I was quite alarmed to hear the backlog. And I know it's out of everybody's control per se. We've never navigated these waters of a pandemic before. So I'm curious, how is this affecting your clients, like going forward? And maybe just an anecdotal example of how long have some of your clients been detained, waiting for their right to a speedy trial?
Chair, with your permission, I'll go first, and then perhaps Ms. Birchie can jump in as well. Assemblywoman Hanson, the backlog is actually rather frightening. Some clients are out of custody, and I have a trial that was waiting from even before last session. And I'm thankful that she's out of custody, but she's been on high-level electronic monitoring since December of 2018. So the backlog is actually pretty frightening to all of us. I think the DAs are going to have an increased caseload. We're most certainly going to have an increased caseload. And I think we're going to see people waiting in custody for potentially a year or more before a trial is heard. And that's going to lead to bad results for everybody, because if you have a crime that was committed in the poorer communities, sometimes the witnesses are transient. Sometimes our clients are transient and their phones are getting shut off, or they're facing the evictions that have been happening as the moratoriums have been lifted. And so they're harder to get in touch with, and then a bench warrant is issued, and then they're placed into custody, and then their trial is reset in the ordinary course, which means instead of the speedy trial, because they already waived it because they were out of custody, their trial is going to be set 6, 7, 8 months down the line, depending on the court's calendar. So this backlog is frightening us, and I think it's going to cause a serious problem in our system.
If I may briefly, Kendra Birchie, for the record, our courts have been working with stakeholders in order to prioritize, to ensure that those individuals who did invoke, so asked for their right to a speedy trial, to have them be prioritized in our flights for resuming jury trials. And I would just note that I had a trial with an individual who was the first one to be continued due to COVID back in March. We set his trial for November, and unfortunately, due to individuals on the case testing positive for COVID and then the courthouse shut down, that trial is still pending now again for March. So as long as hopefully the jury trials resume, but that's just to give some information of that person is still in custody.
Thank you. I know we're short on time, Chair, so I'll leave it at that, but appreciate your responses.
Thank you so much. And members, I know there are probably more questions out there, so I apologize, but I want to make sure we give enough time to hear our first bill. So Mr. Pirro, Ms. Birchie, thank you for spending time with us this morning and telling us about your respective offices. We look forward to having you in committee on a regular basis and working with you this session, and please have a great rest of the day. So we'll close the presentations that we heard, and is everyone ready for our first bill? Because that's what is about to happen. So at this time, I'm going to formally open up the hearing on Assembly Bill 17. Assembly Bill 17 revises provisions relating to the discharge of certain persons from probation or parole. I want to welcome back to the committee, one second here, Chief Lawson, who's going to present the bill to us. Committee members, there is a short PowerPoint presentation that I believe Captain Lawson will share a screen with us, but it is available online for committee members of the public. And what we'll do is give the chief a chance to present the bill. Then we'll take questions from the committee before going to testimony in support, opposition, and neutral. So Chief Lawson, welcome back, and please take it away.
Good morning. Can everybody see the presentation that I just shared?
Hello, Mr. Lawson. This is America with Broadcast. We are only able to see what I believe is your email.
Oh, that's not even my email. Let me hide that. I think I grabbed the wrong screen. Excuse me.
It's okay.
Oh, sharing that one.
And if you could, from the
There it
screen
is.
share, pick the
I have it.
application specifically.
How's that?
That looks great. Thank you.
Awesome. Apologize for clicking on the wrong screen there. So good morning. Thank you, Chairman Yeager, and I'm honored that you are hearing our bill first of all the work you'll have to do this session. So good morning, Chair. Thank you for that, and welcome. Thank you again to the members of the committee for inviting us here today.
Mr. Lawson, I apologize for interrupting you again. We are unable to see your screen share, so I'm going to stop it. And if we could just try restarting your screen share again. We just want to make sure it's going through to broadcast.
How's that?
One second.
one
All right.
minute. Oh, it was up.
We could. Sorry, we could see it. I was just waiting for confirmation.
Sorry.
So let's pull it back up. 1 second. We are still having difficulties. I am going to stop your screen share one more time. And if we could try again, I would appreciate that. All right, Mr. Lawson, we are getting a good visual, so you may continue with your presentation.
Okay, thank you. So under existing law, the court is responsible for ordering either an honorable or dishonorable discharge for probationers who are completing their term of supervision by the division. For parolees, the division issues the discharge and reports that finding back to the parole board. Historically, there has been a distinction between an honorable and dishonorable discharge, and that distinction has been related to the restoration of civil rights of the supervised individual upon completion of their term of supervision. During the 79th and 80th legislative sessions, legislative action has, I guess, eliminated the distinction between the rights restored following a honorable versus dishonorable discharge, and now the restoration of rights are identical regardless of the type of discharge that's received by the supervised individual. So because of that I guess, lack of distinction between the types of discharge between honorable and dishonorable, and that the civil rights are restored identically in either case, the division seeks to remove that distinction of honorable versus dishonorable discharges from the applicable statutes, and I guess issue what it would be termed, I guess, as a general discharge. It's a discharge for everyone expiring supervision. Some of the benefits of this change are that continued classification of dishonorable versus honorable discharges could be misleading to prosecutors and the courts for future prosecution and sentencing decisions. This practice could ultimately lead to individuals who are dishonorably discharged due to circumstances beyond their control being categorized inappropriately in future criminal justice actions. Relatively compliant offenders receive dishonorable discharges currently, and relatively non-compliant offenders receive honorable discharges based upon the way the differentiation between honorable and dishonorable is worded within existing statute. This change would also help to alleviate some of the procedural distinctions that we're realizing that caused this delays with the offender receiving their actual discharge paperwork from the court. When there is a difference between the judge's view of whether it should be an honorable versus dishonorable award versus what the statute requires us to recommend. At times, the judges choose not to sign the discharge, and in that case, the offender is in a state of limbo We do not, as the division, have the legal authority to continue supervising them since they've expired their term. However, they don't have their official discharge document because that process isn't followed. By eliminating that distinction, then our view is that it would speed up that process and allow those cases to proceed more expediently. Additionally, the distinction could limit former offenders' options and opportunities to gain access to supervision in the future if they were labeled as honorable or dishonorable, and as a dishonorable, maybe that brands their supervision for the future. In the current environment of justice reform, it is incumbent upon the state to examine all processes that may create obstacles and barriers to continued rehabilitation and access to assistance. The assertion of honorable and dishonorable discharge is one such possible obstacle, and the elimination of the requirement allows for an individual to be assessed on the merits of their criminal record and factual compliance during supervision, and not on a potentially erroneous and unnecessary label. And I also would like to note these changes do not impact any of the recent added language from last session of AB 236 relative to the early discharge of offenders from parole or probation. In fact, those statutes, when they were authored, those changes were made last session, do not provide a distinction in regards to early discharge. It was just that they're eligible for an early discharge. It does not define whether that discharge should be honorable or dishonorable. I'm a little embarrassed to have to say that one element we didn't think about when we wrote our executive bill draft was in terms of the reporting requirements from AB 236 relative to our reporting to the Nevada Sentencing Commission. And so our friends at the Nevada Department of Sentencing Policy pointed out that we missed some conforming language in our bill to address the report we provide to the Department of Sentencing Policy for their creation of that report to the Sentencing Commission. And we've worked with them, and they've offered this friendly amendment that we would ask the committee to consider as it evaluates the bill. And this just makes a conforming change to the reporting requirements of the division. Should this AB 17 be approved, and incorporating this removes the distinction of discharge from the report elements we provide to the Sentencing Commission through the Department of Sentencing Policy. In addition, we've reached out to the other stakeholders that may be impacted by this bill, specifically the ACLU, the public defender's offices of both Clark and Washoe counties. We've also spoken to the prosecuting attorneys for Clark and Washoe counties, as well as Chairman DeRico of the parole board. Hopefully Mr. Piro and Ms. Birchie are still online, and our conversations with them have been very positive. And I'll let them speak for their view on this. In terms of representing the district attorney's offices, they expressed some initial reservations about the bill regarding the changes. And we're having some ongoing conversations with them, trying to alleviate their concerns that, the distinction of type of discharge is a consideration for them for future charging decisions. And so we're working to find a way to provide them the essential information they need for those future charging decisions, either via the pre-sentence investigation reports or via our discharge reports, to ensure that they have the full picture of the individual's compliance with supervision history, rather than just that one word to describe the type of discharge they received from previous supervision. And so I appreciate your time today. I kept the presentation as short and sweet as I could to get the point across. And with that, I'll turn it over and be happy to answer any questions that the committee may have regarding the bill.
Thank you so much, Chief Lawson. One question that I had, just a clarifying question. In the presentation, you just spoke about it. There's this amendment that, and so I wanted to confirm just a couple of things. That one, this amendment was proffered by the Department of Sentencing Policy, and that you, as the bill sponsor, do consider this to be a friendly amendment to the bill.
Tom Lawson, for the record. Yes, sir, Chairman, I do. We worked very well with Victoria at Department of Sentencing Policy. She proposed the language, and we agree. Like I said, I'm a little embarrassed that we didn't catch it ourselves, and appreciate that her bringing it forward, and it is certainly a friendly amendment.
Thank you so much for that, Chief Lawson. We're going to take questions from the committee. I have a couple people so far, so let's go ahead and take these, and then we'll get to some others, I'm sure. We'll start with Assemblywoman Gonzalez and then Assemblywoman Krasner.
Thank you so much, Chair. Assemblywoman Gonzalez, Assembly District 16 for the record. What happens to people who may have these distinctions in their release and then they come back? So if we're like no longer giving these distinctions, are those still in their record?
Thank you for your questions. This is Tom Lawson again to respond on behalf of the division. So the prior term of supervision will remain in the offender's criminal history. So instead of the previous supervision history just showing honorable or dishonorable, it would show that they were discharged from supervision. And then the support for that and description of their compliance with supervision would be contained in both the discharge report that was provided to the court, which would be available to the prosecutors for future charging decisions, so they could actually view what technical violations or other issues the person had with supervision, as opposed to just that one word of honorable or dishonorable. The information is still available, and that was some of the resolution we're attempting to find with the prosecuting attorneys, is how to give them the actual supervision information rather than that one word descriptor.
Please go ahead and follow up, Assemblywoman Gonzalez.
Thank you so much, Assemblywoman Cecilia Gonzalez, Assembly District 16. So, sorry, it's unclear. So are you going back into their files to change this description, or is it just if that person were to come back, then it would just say that they were discharged?
Thank you for clarifying that. Tom Lawson again for the record. No, this would be for future discharges. After the effective date, any discharge issued for probation or for parole would just be a general discharge overall, and we would not go back and reclassify previous discharges. That certainly isn't the intent here. I guess in the overall scheme of things, to put that into scale, since the start of our Otis system, we have about 215,000 offender records in that system, and that just wouldn't be, I guess, feasible to reclassify all those.
Okay, let's take a question from Assemblywoman Krasner, please.
Oh, thank you, Chair Yeager. Assemblywoman Lisa Krasner, Nevada State Assembly District 26. My question is, what would a person have to do initially to receive the moniker of dishonorable discharge? What does the person have to do to receive that term attached to them, please?
Thank you. Tom Lawson for the record. The qualifications for an honorable or dishonorable are covered by the statutes we're looking to amend here. NRS 176A.850 covers the requirements for probation, and then NRS 213.154 and 155 cover the parole side of it. And some of that is tied to their ability to pay fines and fees. There's a general statement regarding compliance, but it's very open-ended. So some of that is a discretionary element of the court of whether they deem them to be compliant, or if they were able to pay their fines and fees. And unfortunately, I don't have the exact verbiage available to bring up with the presentation, but those are the statute references. So now the statute is written to say that, excuse me, I do have that in the bill draft itself. Just one moment, please. Okay, so the current statute is section 2 of the bill, of the red line version of the bill. And currently it reads, a person who has fulfilled the conditions of probation for the entire period thereof is recommended for early pardon me, that's the wrong section. That's early discharge. Okay, a person may be granted a honorable discharge from probation by order of the court. If they have essentially, it's the demonstrated fitness for honorable discharge, but because of economic hardship, verified by the division, have been unable to make restitution payments, and essentially have been fulfilled the conditions of probation for the entire period thereof. For parole, parole is section 4 of the bill, and it says current statute is the division shall issue an honorable discharge to a parolee whose term of sentence has expired if the parolee has fulfilled the conditions of his or her parole for the entire period of his or her parole, or demonstrated his or her fitness for honorable discharge, but because of economic hardship verified by the division, has been unable to make restitution payments as ordered. The division shall issue a dishonorable discharge to a parolee whose term of sentences has expired if the whereabouts of the parolee are unknown, the parolee has failed to make full restitution as ordered by the court without a verified showing of economic hardship, or the parolee has otherwise failed to qualify for an honorable discharge pursuant to section 1. And so most of the distinction is tied to fines or fees and their ability to pay. I guess technically, if you look at somebody who has a very large amount of restitution owed, a specific example I can think of was a lady who owed over $200,000 due to an embezzlement case. During her term of supervision, which was approximately 15 months, she was able to repay $40,000 of that amount, which I think is a substantial accomplishment given the likely earning potential of somebody with a felony on their record. And so this person has made a significant effort to pay their restitution, but it's an arguable point of whether that was enough to earn an honorable discharge or not. And so, like I said, we have people on record who have earned or been labeled as a dishonorable discharge, even though they've given a very good effort towards paying their restitution and fees, but are just incapable of doing so within the supervision term, given the amount that might be owed or their earning potential. And so, my worry is that, if somebody has a choice of making a restitution payment or putting food on the table for their children or housing their family, it's kind of looking at Maslow's hierarchy of needs, that's a simple decision for most people to make. They're going to feed their children before the restitution. And so when they do or provide as much as they possibly can while meeting those basic, health and safety needs, to label it as a dishonorable discharge, I think is relatively unfair. And that's one of the things we're looking to address here.
Please follow up.
Yes, thank you. So two things. I did read the bill. Is it only not paying restitution that constitutes a dishonorable discharge? Because my concern would be, like, say there's a child molester and they are out on parole and probation and they're hanging around the preschool every day, which violates their terms of parole and probation. But are they still now, they're not labeled dishonorable discharge? I'm trying to understand that.
Right. Tom Lawson for the record. So in that case, that would be an actual violation and really, possibly a new crime could be committed there. So that that would be part of their compliance with the conditions or fulfilling the conditions of their term of supervision. And so in that kind of case, again, it's not labeled within statute. Could a judge order that to be an honorable? Possibly. That's within the discretion of the court, given the statute. All those factors would certainly be considered, and that would be part of that compliance with terms of supervision of whether they would be awarded an honorable versus dishonorable in this case. But again, the important part of that is that compliance with supervision would be documented within the discharge report and referenced in a future PSI. So regardless of that one-word descriptor, the evidence, the factual I guess, information regarding their compliance with supervision for future prosecution and placement of supervision determinations would be available to both the court and to the prosecuting attorneys, even with a change.
And before I take other questions, let me just ask a clarifying question, Chief Lawson. Nothing in this bill would prevent the Division of Parole and Probation from seeking a revocation of parole or probation and asking a judge to send someone back to prison if they were to do something that egregiously violated their terms of supervision. Is that right?
Yes, sir. This is Tom Lawson for the record. That's a very good point, is that this only deals with that out processing of the supervised individual as they expire their term of supervision. So if they're non-compliant to the point of either exercising through multiple technical violations in our intermediate sanctions matrix, to the point where there's repeated offenses that have escalated to seeking revocation, or if the offense was egregious enough to seek revocation immediately, or if they're being charged with new charges, new criminal offenses, then that wouldn't be addressed here. That would be independent. So those sort of people, like in your example, Assemblywoman, of the convicted sex offender who was, at the park or actively soliciting children, that would be addressed independently of the discharge. And again, those facts would be placed within the completion records, the discharge records of the current case before initiation of the next case.
And let me just make a quick clarifying remark, because I know this is our first bill and we haven't gotten into some of this, but for those who aren't versed in the criminal justice system, if you get probation from a judge, there's always a suspended sentence that you're given. So essentially a judge would sentence you to jail time or prison time and hold that sentence over your head to see how you do on probation. And so, there are times where if you don't do well on probation, then you go back in front of the court and the judge can impose that time and send you to prison or to jail to do your actual sentence. So we're not talking about that piece today. That's known as revocation. I think what we're talking about today is when you get to the end of the line and parole and probation is looking at how did you do on probation and should we recommend an honorable or dishonorable. That's sort of what we're talking about. And then on the parole side, very similar. Parole is when you are already in prison, you got released, but there's still some of your sentence that's hanging over your head. And so, you have to follow conditions of parole. And if you don't do well in that, then a judge could send you back to serve the remainder of the sentence. So I just wanted to be clear that we're not tying a parole and probation or a judge's hands to say you can't send someone back to do the rest of their sentence if they're, really performing poorly on parole and probation. So I'll stop talking because I have a number of other questions. And let's go next to Assemblywoman Cohen, please.
Thank you, Chair, and thank you, Chief Lawson, for the presentation. After listening to you, I now understand the point of the bill being that we've got this one-word descriptor. It's not always accurate, and that's why, and that is harmful to former offenders who are trying to get their life back. But what I want to know is, because the vast majority of us don't know that the one-word descriptor isn't accurate, and honorable sounds good, dishonorable sounds bad. But when a former offender had that certificate of honorable discharge, they had something they could show to anyone in their sphere as they're getting jobs, as they're looking for homes, that type of thing. Look, I've got the certificate. It says I was released honorably. It shows that I'm getting my life back together. I'm doing what I'm supposed to do. I'm complying with the law. I'm complying with the terms of my probation or my parole. So is there an alternative now for someone that they can show, look, here's my progression. Yes, I was convicted, or I was, I served time, but here's what shows that I'm on the straight and narrow to being a good citizen right now.
Thank you for the question, Tom Lawson, for the record. The current laws for both parole and probation require that the offender upon discharge receive the document outlining the restoration of their rights. And that would not change with this law. The only thing would be, again, that one word descriptor. So even then, yes, beyond that, there was no detailing of you had this many technical violations or you did not have any technical violations. In that descriptor, it was just you have been discharged, this is the type of discharge, and here are your reinstated rights. So no, that wasn't, I don't know a way that would, I guess, demonstrate that well publicly. You're talking about somebody's criminal history in regard. So, is there desire for the offender to share that publicly? Maybe if it was positive, but in order to, I guess, do that, you'd have to show both the good and the bad on that document, which I guess would slow the process down initially, but also it also wouldn't necessarily reflect the overall performance. Because if you have somebody who is not adjusting well at the initial part of their term, but come back strong and through counseling and wraparound services and are doing very well at the end, well, if we list all the bad things on that discharge, that might be biased in the same way as the word dishonorable later on when they, completed the term successfully at the end. They didn't get revoked. I mean, that's a success. They finished their term of supervision and have reintegrated into the community.
Okay, thank you.
We'll go next to Assemblywoman Bilbray Axelrod.
Thank you, Chair, for the question, allowing me to ask a question. And thank you, Chief Lawson. I will say your presentation today definitely got me to a level of comfort that I did not have by just reading the bill last night. So I appreciate that. I did have a question about what effect, if any, this would have on people's ability to seal their records, have their records sealed.
Yeah, that's a good point. Tom Lawson for the record. Just thinking off the top of my head here of the record seal statutes, it doesn't talk about whether your discharge is honorable or dishonorable. The qualifiers for record seal are primarily related to time following completion of your term of incarceration, and if you were to expire in prison, for, let's say, or following your term of supervision. So I can't think of any impact there. And likewise, the statute requires that all interested parties, i.e. the division, the parole board, the court, or it's not the court, but the district attorney's office have the opportunity to comment on a petition for sealing. In that case, the facts that were included in the discharge report or the PSI could be the basis for the prosecutor, right? Because quite likely the prosecutor who prosecuted the case may not be the one who is solicited for comment upon record seal when we're looking at terms of 10 years and things like that following the offense. So the documentation for their compliance with supervision, if it were to be considered for those responses, would still be available given the change.
I have a number of other folks who want to ask questions. I'm taking notes here, so you could please be patient. I'll try to get to all of you. We'll go next to Assemblywoman Kasama.
Thank you, Chair, for recognizing me. Question just for clarification as well. So the dishonorable status before you said could be for lack of payment, and could it be, for example, for poor supervision? They weren't following the supervision, not enough to have them go back to jail, but they just weren't following the supervision well, and there was lack of payment. Would that be something that would fall under the category of dishonorable?
I'm Lawson for the record. Yes, that would be under the fulfillment of compliance with the conditions of parole or probation.
And Chair, could I follow up with another question?
Please go ahead.
Yes, so, and I forgot to state Assemblywoman Heidi Kasama, District 2 for the record as well. So help me understand where this certificate is used. So the certificate is issued at the end of the process, the dishonorable versus honorable. Where is that used? Is that brought up if the person is arrested again? Where is this? What is the importance of this certificate, and how does it help that person? when it was dishonorable versus dishonorable.
Tom Lawson for the record. No, it wouldn't be used at the time of arrest. I wouldn't consider it to be used necessarily at the time of a prosecution decision or even that piece of paper at sentencing. Again, the facts would be used in those determinations by the DA's offices in the court. Where it would be used by the offender would be in terms of a question if they were to show up to vote. And there was a dispute of whether they were eligible to vote because of their criminal history. Then the form is available to them to show, now here is my discharge, here is the statement of my restoration of rights. And that's still provided to that person upon discharge moving forward.
I see. So just for clarification, that the main purpose of this would then be for qualification for voting. So if you're honorable, you could be restored the right to vote. If you're dishonorable, you could not have the right to vote. Is that correct?
Tom Lawson for the record, that was just one example. The discharge document that's provided to the offender upon completion of their term of supervision for either parole or probation must include by statute a statement explaining their restoration of their rights. And the right to vote is just one of those rights. The right to appear as a jury member in civil versus criminal cases, those are defined, and those have different timelines of when those rights are restored. So the voting was just one example.
I see. But if you were dishonorable, you couldn't serve as a juror. Is that correct? Under the old system or under?
Tom Austin, again, for the record, prior to the 79th session, there was a distinction between the restoration of life, the 79th and 80th sessions, both altered the timelines of restoration of rights. Now, following the 80th session, the restoration of rights is identical for both the honorable and dishonorable discharge now. And that's one of the I guess, driving forces behind this is if there isn't a difference between the offender moving forward with an honorable or dishonorable, then is that one word distinction necessary going forward?
Could I have one quick one?
Sure, please go ahead.
Just to follow up on the friendly amendment, the other question was, I see that you've written things that need to be included for future reference, but I didn't see on here if restitution had not been paid, had been followed. Shouldn't that, because you're on this amendment, you're talking about supervision issues, recidivism rate. So the person is getting this history, the court is getting this history, but I don't see that it's being summarized whether they fully made restitution or not. Should that be added to that amendment?
Tom Lawson for the record, I don't believe that restitution amount would apply to the friendly amendment. The friendly amendment is merely making a conforming change to the data that the division is required to provide to the Department of Sentencing Policy for their annual report to the Sentencing Commission on certain statistical elements of parole and probation, and also from the Department of Corrections. And so if you look at Section 3 of the bill as written, right now we would have to tell the Department of Sentencing Policy how many people were discharged by type of discharge. And so if there's only one type of discharge, the necessity to distinguish that in the report goes away. And so that's the only change in the friendly amendment, is to say, if we were to remove the distinction of honorable versus dishonorable for both parolees and probationers, then the division does not have to distinguish honorable versus dishonorable in this annual report we provide to the Sentencing Commission. The restitution is not altered under the statutes we're seeking to amend, i.e. 176A 850 or 213 154, the respective statutes for discharge for parolees and probationers. Their obligation for restitution does not go away. In fact, we work closely with the LCB on the drafting of the bill to ensure that it was very clear that upon discharge, the obligation to pay restitution continues. And it says specifically in the statute, talks about how it becomes a civil liability at that point.
Thank you.
All right, let's go next to Assemblywoman Gonzalez.
Thank
Thank you so much, Assemblywoman Cecilia Gonzalez, Assembly District 16. I was curious, and I don't know if I missed that. What is the overall weight of this one word descriptor in this discharge process? Because you previously stated that, you know, if someone can't pay restitution, it's unfair for them to have an unhonorable discharge. And so I'm just curious, what is the actual weight that these words have that you see in your everyday cases? And or like, what is the real need for this to change?
Thank you. Tom Austin for the record. That one word could be relied upon. I guess I can't speak on behalf of all those who would view the discharge in one view or the other. But by, I guess, eliminating the opportunity or requiring, really, it's asking those who would look at the person's criminal history for future decisions to delve into their actual supervision history and not rely on a single descriptive word to classify that entire behavior. As I said, you may have somebody who comes out of prison and doesn't adapt very well because of the changes or their economic situation. But as the supervision term continues and they receive some services and they establish a job and are able to provide for themselves, then they're more compliant as the term of supervision goes on. And so when they may have had difficulty at the beginning, they're very successful at the end. To have that opportunity to possibly be only judged on that initial period of difficulty in adjusting to classify the overall term of supervision doesn't accurately represent the positives that individual attained throughout their term of supervision. And so by eliminating that and requiring you to look at the overall descriptor or the overall facts of their supervision case and then make a determination of whether they did a good job overall or not do a good job overall based on the totality of the circumstances instead of one word, I guess is the ask for some of the outside stakeholders. And again, it also mentioned it streamlines the process a little bit for us in terms of focusing on the discharge. Some of the things that we've thought about with Speaker Frierson's question when we did our overall introduction presentation before to the Joint Money Committees was related to some impact of AB 236. And that's one of the things we expect is that shorter probation terms, early discharges, and some of those other things are going to speed up the supervision process for us administratively. And I guess streamline that process in terms of not having to debate the facts of a honorable or versus dishonorable discharge would help the division. And again, it's not that we're not providing the factual information for those decision makers to make an accurate assessment of that. It's that we're not providing it in the simple one-word descriptor.
Thank you so much.
And I think Assemblywoman Gonzalez, you asked the same question that Assemblyman Wheeler and Assemblyman O'Neill had, as far as I know. So good job on knocking out 3 questions there with yours. Any other members have questions? Just give me a show of hands if you have one. Okay, I don't see further questions, which is good because we do need to move the bill along. So Chief Lawson, free to stay on the line and make some concluding remarks at the end of the hearing. I want to thank you for your presentation. And what we're going to do now is go to testimony in support. And committee, we're going to try to figure this new world out. I know I have at least maybe 1 or 2 on video who are going to support, and I'm going to ask them to try to keep your comments to 2 minutes, given that we have a floor session in a half an hour. So I'll go to you first, Mr. Pirro, if you'd like to provide testimony in support.
Thank you, Chairman. John Pirro from the Clark County Public Defender's Office. We are in support of this and thank Chief Lawson for bringing this bill idea to us. I just wanted to answer some of the questions that were brought about. Assemblywoman Krasner, that situation that you brought up, that person would absolutely probably go to jail or prison for violating their terms of probation. And so that would be the sentence that person would get. The change in this word removes some of the arbitrariness of the criminal justice system, and that's why we are fully in support of this legislation. And Assemblywoman Kasama, you had brought up restitution. That wouldn't be used in a PSI or any other way. And under law, restitution can be boiled into a judgment that a victim can then collect on if it wasn't fully paid during the time of supervision. So we are in support of this bill. We thank Chief Lawson for bringing it forward. Again, it will remove some of the arbitrariness of the criminal justice system in between who gets a dishonorable, who gets an honorable. When their sentence ends, it ends, and it's just a discharge. For sentencing purposes going forward, a PSI, the pre-sentence investigation report, would tell the court whether or not a person went back to prison or jail on probation. So the court would know if a person picked up a new charge after probation, whether or not a person was actually successful on probation based on whether or not they went back to jail or prison during their term of probation.
Thank you, Mr. Pirro. Any questions for Mr. Pirro before we let him drop off the line? Okay, I don't see questions. Thank you again, Mr. Pirro. Ms. Birchie, did you want to provide testimony in support as well?
Yes, please. Kendra Birchie, Kate. I don't know if you need me to spell it too on this, Kendra Birchie, Bertschy with the Washoe County Public Defender's Office. We are in full support of this bill as well as the friendly amendment, and thank Chief Lawson for allowing us the opportunity to work with him on this bill in order to ensure that we're doing everything we need to advance what we did this last legislative session, or this committee did with AB 236. I'll just add that the judgment that Mr. Pirro mentioned is called a civil confession of judgment that is done all the time in order to ensure that victims do receive their restitution. And that's outside of the criminal case. It's done in the criminal case, but when the case is closed, then there's still that civil case in order for victims to receive their restitution. The information that would happen from a probation, if there was any issues, would still be outlined in the PSI, regardless of what the definition or how it's determined. However, if someone receives a dishonorable discharge just because of financial inability to pay, that information is not included in a pre-sentence investigation report. And that's why this is extremely important in order to ensure that the inequities that are currently in our justice system are resolved. Thank you.
Thank you, Ms. Birchie. Any questions for Ms. Birchie about her testimony and support? Okay, I don't see questions. We don't have anybody else on video in support, but we may have callers on the phone. So I'm going to ask BPS if we can check to see if we have any phone calls in support. And committee, I just asked you to be a little bit patient because there's a slight delay between the meeting and the phone line. So we may have to wait a little bit to see if we have anyone on the phone. So BPS, if you could please check that out.
Good morning. Thank you, Chair. For callers wishing to testify in support, please press *9 now to take your place in the queue. Callers wishing to testify in support, please press *9 now to take your place in the queue. And we will begin with the first caller with the last 3 digits of 667. If you would please slowly state and spell your name for the record. You have 2 minutes to speak and may begin. Caller with the last 3 digits of 667. Go ahead.
Hello, my name is Nelda Wagan. Can you hear me?
Yes, go ahead, caller.
Okay, so my name is Nelda Wagan. My last name is spelled Weygant. I'm with Return Strong Families United for Justice for the Incarcerated. I'm here to talk about honorable and dishonorable discharge from parole and probation. In my experience, I have both been honorably and dishonorably discharged. Prior to my dishonorable discharge, I was unable to pay restitution and penalties and fines due to my financial hardship. I would also like to say that during this time, I was depressed due to the financial situation, and that I had pressure from the PMP on trying to complete my probation on time. I was just honorably discharged a few days ago. Before even being able to be submitted to the judge, I was required to pay all fees and restitution, and was told that even if I got a traffic ticket, I would be denied. Even though that since I was being released from jail, I was diagnosed with multiple health problems and multiple mental health problems, I was still required to keep a job and to be able to pay everything before I was able to be submitted. The way I feel from going from being dishonorably discharged to being honorably discharged is that it made a big, huge gain in my self-worth. Being dishonorably discharged from probation, it made me feel like a lack of self-worth, and being honorably discharged, it made me feel like I was more self-worthy than I was before because I could make the payments now and I couldn't then. So I'm in favor of the AB 17, and I just want to thank you for your time.
Thank you so much. I appreciate your testimony.
Thank you. And we will take the next caller with the last three digits of 360. Caller with the last three digits of 360, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you. Good morning. My name is Sarah Hawkins, SarahHawkins. I am the president of Nevada Attorneys for Criminal Justice, testifying in support of AB 17. I would like to start by acknowledging the fact that AB 17 promotes the interests of justice for those who very unfortunately come back to the system. As Mr. Pirro pointed out earlier, I am also a public defender. I don't want my clients coming back into the system. But I think AB 17 does more than that. I think it incentivizes not coming back into the system, and it contains benefits to all Nevadans, including victims of crimes. So I'm going to focus my comments there. AB 17 rightly acknowledges that parolees and probationers who comply with substantive non-monetary conditions should not be penalized for poverty. Trying but being unable to find a job, making substantial efforts to pay restitution but not paying in full, inability to earn enough money to pay all fines and fees but otherwise complying perfectly with substantive conditions, these efforts are not dishonorable. They are symptomatic of poverty. Persons who transition from incarceration to parole or probation rarely have financial resources. And even when they do, it's almost never enough to cover human needs like food, housing, and medical care, much less restitution and other fines and fees that are associated with community supervision. Labeling a discharge dishonorable exacerbates these challenges. The practical reality is that district attorneys and judges use the word dishonorable as shorthand in judging whether a criminal record sealing petition should be granted. Excising honorable and dishonorable distinctions from the law, as AB 17 does, will transform this practical reality to serve the interests of justice, because no person should be judged on a single word. Having your record sealed opens a world of possibilities in terms of employment that can ensure restitution is paid to victims after the expiration of a parole or probationary term. The challenges of those that transition from community supervision will be eased. And we may even see recidivism reduced. NACJ's only request is that AB 17, that this committee consider amending AB 17 to apply the presumption in favor of record sealing retroactively to all probationers who have been dishonorably discharged. This is a small addition to an already excellent piece of legislation and will ensure that its goals are fully actualized to the benefit of all Nevadans. Thank you.
Thank you so much for your for your testimony and support. EPS, do we have anyone else to support?
Yes, thank you. Caller with the last three digits of 695. Caller with the last three digits of 695, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good morning. My name is Victoria Gonzalez, VICTORIA GONZALEZ, and I am the Executive Director of the Department of Sentencing Policy. As the Chief said, our department collects data from agencies, including the Division of Parole and Probation. We partner with the division on a regular basis, including on the development of the amendment that he proposed as a friendly amendment, or he introduced as a friendly amendment. As Chief Lawson said, the conforming change in the amendment ensures the data that the division is required to submit to our agency is consistent with the manner in which the division supervises. Therefore, our department supports AB 17 to the extent that the impact of AB 17 has a neutral impact and assists agencies in effectively implementing AB 236. Thank you.
Thank you so much, Ms. Gonzalez. Appreciate it. BPS, anybody else in support?
Yes, we have a second caller with the last three digits of 695. Caller with the last three digits of 695. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning. My name is Holly Wellborn, Policy Director for the ACLU of Nevada. I love that Ms. Gonzalez and I have the same last three digits. And our phone number. It's a pleasure to be here testifying for the first time this session. Welcome back to those of you that I've worked with in the past, and I very much look forward to working with the new members on this committee. We are in support of AB 17. The distinction between honorable and dishonorable discharge at the expiration of a term of parole and probation is rooted in the same discriminatory structures that plague our entire justice system. The Nevada Legislature, with bills originating from this committee, passed laws restoring the right to vote, streamlining record sealing processes, and will hopefully continue to work to resolve the inequities in our criminal justice system. AB 17 does just that while also making parole and probation's job much easier. So it's a win for everyone. I want to thank Chief Lawson for putting so much time and effort into this bill. We've been speaking with him for months about this, and we're very excited when he approached us about this. I think that a lot of state agencies, government agencies can learn from his leadership and bringing people to the table for collaboration. So thank you so much for bringing this forward. We're in strong support of this bill. Thank you.
Thank you, Ms. Wellborn. It's good to hear from you. BPS, anybody else on the line?
Thank you, Chair. Any further callers in support, please press *9 now to take your place in the queue. And we will take caller with the last three digits of 037. Caller with the last three digits of 037. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Tanya Brown, spelled TONJABROWN. Good morning. This is Tanya Brown, Advocates for the Inmates and the Innocent. We strongly support this amendment and the friendly amendment. So I'll just make it really brief. I don't know if I missed this or not, but I know that over the years, some of the inmates coming out on parole wished that they could have something favorable from their parole officer in writing, so that way they could present it to someone if they're applying for a job or things such as that. So would that be possible to do as well with the parole officer? They're the ones most familiar with the parolee, just like the caseworker is most familiar with the inmate. To get a favorable letter written from the parole officer and present it to the parolee. Thank you. Have a good day.
Thank you, Ms. Brown. BPS, any other callers in support?
Thank you, Chair. Callers in support, please press *9 now to take your place in the queue. Any callers wishing to testify in support, please press *9 now to take your place in the queue. And Chair, there are no further callers in support.
Thank you so much. So we'll go ahead and close support testimony. At this time, I'm going to open it up for opposition testimony. I don't believe we have anybody on video with us in opposition today, but I suspect we may have one or more callers on the phone. So BPS, if you could queue up the phone callers in opposition, I would appreciate it.
Yes, thank you, Chair. For callers wishing to testify in opposition, please press *9 now on your phone to take your place in the queue. Callers for opposition, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 648. Caller with the last 3 digits of 648, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning. This is John Jones, John Jones, on behalf of the Clark County District Attorney's Office and the Nevada District Attorneys Association. I want to thank Chairman Yeager and members of the Judiciary Committee for the opportunity to speak this morning. We are here in opposition to AB 17, but I want to start off by thanking Chief Lawson and Major O'Rourke for meeting with the DAs and discussing this bill with us. As DAs, we truly value the work that parole and probation does, both to protect our community and to assist in the rehabilitation of offenders. We have 2 major concerns with this bill, and the first of which is that current plea negotiations have been built around the honorable dishonorable designation. In Clark County, you will regularly see a negotiation where a defendant may earn a reduction in the charge to which they pled, meaning that they can withdraw their plea to a felony and plead guilty to a gross misdemeanor or even a misdemeanor. The trigger for this reduction in the guilty plea agreement is whether or not the defendant received an honorable discharge from probation. Our second concern is the removal of a layer of accountability for defendants who complete community supervision. In our opinion, the designation of honorable or dishonorable both serves as an incentive for those currently under community supervision to do their best, and it also serves as a good reference point for the justice system should the defendant reoffend in the future and request probation again. While, as Chief Lawson indicated, the courts are the one that actually issue the discharge, in virtually all cases, they follow the recommended discharge from P&P. We have become aware through the process of communication with Chief Lawson and Major O'Rourke that there are some inconsistencies surrounding implementation of these discharges as applied to the various defendants. We are committed to working with PNP and others to make the designation more accurate without creating an administrative burden on an already strapped agency. With that, Mr. Chair, I want to say we are endeavoring to work with PNP on a solution to this as we move through the legislative process. And again, we are opposed to AB 17, and I want to thank the members of the committee. Thank you.
Thank you so much, Mr. Jones. Mr. Jones, if you do have your, I don't know, I can't tell if you were reading from something or not, but if you do have your comments in writing, if you wouldn't mind providing that to the committee manager, that will help with the preparing of the minutes. And if you don't, that's perfectly fine as well. BPS, do we have anybody else on the phone in opposition?
Thank you, Chair. Anyone wishing to provide opposition, please press star 9 now to take your place in the queue. And Chair, there are no further callers in opposition.
Thank you so much. So we'll close opposition testimony. I'll now open it up for testimony in the neutral position. I don't believe we have anyone on the video in neutral, but let's check the phone lines to see if there's anybody there. BPS, just let me know if we have any neutral callers, please.
Yes, thank you, Chair. For callers wishing to testify in neutral, please press star 9 now to take your place in the queue. Callers who wish to testify in neutral, please press star 9 now to take your place in the queue. And Chair, the phone line is open and working. There are no further participants at this time.
Thank you. We'll go ahead and close neutral testimony. And Chief Lawson, I want to give you an opportunity, if you're interested, to provide concluding remarks on Assembly Bill 117. So if you'd like to provide those now, please go ahead.
Thank you, Chairman Yeager. Tom Lawson for the record. I just want to briefly close by thanking you again for your time and for honoring us as the first bill that you've reviewed this legislative session. And if there are any questions that come up, my contact information is included in the presentation. I would welcome the opportunity to speak offline or to reply to those questions in writing. Thank you again.
Thank you so much, Chief Lawson. And before I close this bill hearing, just for our new committee members, as a reminder, it is in our standing rules in the Assembly, but with rare exceptions, we will not take action on a bill that we hear without a minimum of 24 hours passing for members to be able to digest the bill. There are, of course, times at the end of session where that may become impractical and the rules may be waived. But for now, rest assured that this is not going to be on a work session anytime real soon. So what I would encourage members to do, sometimes after the hearing, you review the bill and you have additional questions, reach out to Chief Lawson, reach out to the supporters of the bill, the opposition of the bill, make sure you get your questions answered. And if we do have a chance to process this bill, you will get ample notice that the bill is going to be processed in committee. That will normally happen on Fridays, not always, but normally we reserve Fridays for work sessions. So with that being said, thank you, members, for a successful first bill hearing. And I'll now formally close the hearing on Assembly Bill 17. That takes us to our last item on the agenda, which is public comment. As usual, we'll take up to 30 minutes of public comment. Speakers calling in will have up to 2 minutes to provide public comment. BPS, could we go to the public comment line and let me know if there's anybody there who wants to provide public comment?
Thank you, Chair. Any callers wishing to provide public comment, please press star 9. Callers wishing to provide public comment, please press star 9 now to take your place in the queue. And we will take caller with the last 3 digits of 037. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Tanya Brown, TonjaBrown. Tanya Brown, Advocates for the Inmates. Good morning. I'd like to state, due to the COVID situation we are now in, things have dramatically changed, such as the way we testify before you. I'd like to apologize for yesterday when my dogs decided it was time to play. Due to my recent knee surgery, I was unable to control them, and it will probably happen in the future. So I want to apologize up front to you. I'd like to give a little history to the new members of who I am and about my advocacy and why I became an advocate. I became an advocate because my brother was wrongfully convicted of a crime he did not commit. He spent 21 years incarcerated, and just prior to his death in 2009, the Honorable Judge Bryn Adams ordered the Washoe County District Attorney Dick Gammack to turn over the entire file in the case. When the file was turned over, the handwritten notes of the prosecuting attorney showed that he had defied a 1988 court order to turn over all of the exculpatory evidence and materiality, evidence favorable to the defendant. In the file, there were over 200 documents. Those documents consisted of exculpatory materiality evidence. A state's witness who had a motive and reason for their testimony, it was financial gain. The witness also had problems identifying the defendant's voice from another person. However, the courts continued to refer to this state's witness as credible. Yesterday, I briefly spoke about the sworn affidavit under penalty of perjury, consisting of approximately 75 pages. I ask that you read it so that when people come before you thinking that they know about this case, I can assure you that they do not. But they may know some of the facts, but not the entire case. There have been times where people have come and spoke and testified before the committees who have misrepresented the facts of this case to the legislature. And so in part, that is one reason for my sworn affidavit. I would also like you to know that, yeah,
Brown, can I
I'm
ask
almost,
you
is the 2 minutes up?
just a second? Yeah, we're at a little over 2 minutes, so if you could just please wrap up, we'd appreciate it.
Okay, so I will just let you know that I will just let you know that I have never been arrested for filing a false complaint. I've never been sued by anyone named in the affidavit, nor has anyone sued the author of our nonfiction book to prove his innocence. So I would like you to keep that in mind when you read the affidavit. The evidence does support it. There is documentation, and it is very telling on the way the judicial system works. Thank you and have a good day. Bye-bye.
Thank you, Ms. Brown, and we're wishing you a very speedy recovery from knee surgery, and hopefully we can see you here in the building soon. BPS, do we have anyone else in the public comment line?
Thank you, Chair. Caller with the last 3 digits of 556. And Chair, the caller hung up and there are no further callers on the line at this time.
Thank you so much, BPS. Appreciate all you're doing to make these connections by phone in this virtual world. So thank you for helping us through the hearing today and for navigating that for us. Committee members, we're going to close public comment. Let me get to my gallery view here. Anything else from members of the committee before we close today's meeting? Okay, I don't see anything else. I know I say this all the time, but I want to thank you guys. It was a very long meeting today, over almost 3.5 hours. We got through our first bill hearing. I appreciate your thoughtful, insightful questions. Good news is tomorrow, we aren't starting until 9 o'clock. So you'll have the choice of whether to use that extra hour to catch up on sleep or catch up on work or a little bit of both. But we'll be here at 9 a.m. We'll hear a presentation on juvenile justice, and then we're going to hear our second bill tomorrow. Friday, we have a pretty packed agenda as well with a presentation and 2 bills. So we'll take those as we get them. Look forward to seeing all of you at 9 a.m. tomorrow morning. This meeting is adjourned.